Thank you, Anjali ji. Anjali. Okay. Meeting has been recorded. I have the share rights. QG. So we have how many people we have? We have okay, we have enough people to start our program. Today we are going to learn. I'm audible clearly? Anyone? Should I raise
Oh,
my
we are
voice?
good. Yes, sir.
Is it
You
now
are
clear? Okay, perfect. So today we have chosen this topic of impact of CIRP on personal guarantors. In fact, if any one of you are, appearing in front of NCLTs, today if you check the board of any NCLT, or even if if you see the bankers when they are inviting quotations, uh, I think personal guarantees are talk of the town these days. So, because CIRP, whatever legacy debt we had, that we have covered, many cases have already been done. Now we are targeting the personal insolvency, that is individual personal guarantors. Before we get into the impact, see, impact, one simple impact, we all know that it is affecting them badly, isn't it? That they never knew that this personal guarantee, when they gave in 2011, 2012, 13, nobody knew that this law, IBC law, will come and bite them, in 2017, 18, 19. Correct? This PG to CD, it actually, anyone can tell me when this was introduced? Not IBC. When the notification for PG to CD was done, personal guarantor to corporate debtors. When was this notified or came into force? Anyone here or not yet? Anyone knows when the IBC came into picture? When it was?
sir. 2016.
What was the date?
1st December, sir. 1st December 2016.
Absolutely. So 1st December 2016 was our IBC. Thank you, Single Up. Exactly 3 years after that, 1st December 2019, PG to CD came into picture. Fine. And obviously, we also have heard that there was so much of litigation also went around it, and so it was notified in 1st December 2019. But then Lalit Kumar Jain and after that Dilip Jiwarjika, two of the prominent cases, which went on in Supreme Court for quite some time. And now after Dilip Jiwarjika case, where Chandrachud Saab has given a detailed uh, you know, explanation on what PG is, what PG is allowed. No constitutional rights have been taken away from PG. Now, full-fledged, we are, when I say we are, see, though we are a neutral party, but at times when banks appoint us, so I end up saying we are going after them. So it's not that we are, but yes, that process is now allowed for the PGs. Before getting into this, I wanted to bring something here, which is how many of you have actually read what is the Indian Contract Act says on guarantee, personal guarantees? Has anybody read that? Or even if you have read, since we have enough time today, we have around 3.5, 3 hours almost. This is our Indian Contract Act. My screen is visible or
No, sir, not visible.
not visible? Okay, let me
But
share.
you are visible, sir. To me,
Okay,
you are visible. Yeah.
Yes,
nice.
we can see now, sir. The screen is
Now you
visible.
can see. Okay, so see, I don't know if every one of you is advocate here or not. See, when we are advocates, we know that this section, that section. We also read these books called, these yellow books, Bare Acts. But if most of you are not advocates, then you may not have gone through it. And let me first, first few minutes, or we'll learn what actually the Contract Act talks about guarantees. Uh, we'll go through very slowly, because if you understand the guarantee, you will understand personal guarantee, and then we will understand the impact. And this is the only thing they keep challenging. Personal guarantors, they keep challenging all this limitation and invocation. Two are the most contested things which they challenge in the courts. Now, Indian Contract Act 1872, uh, it's our contract of guarantee. It starts at chapter 8, and guarantee starts at 126. So Indian Contract Act section 126, the guarantee starts. What it says? Contract of guarantee, surety, principal, debtor, creditor. What it says. So this is like a definition of these things. Contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case that third person defaults. So the person himself or herself has not taken anything directly. They are saying, okay, fine, if in case this person is not able to do, then I am here. Don't worry. I am here, I will give it to you. The person who gives the guarantee is called surety. Person in respect of whom the default of guarantee is given is called the principal debtor. In our case, we call it corporate debtor, right? So that corporate debtor is the principal debtor who has actually taken the money. And the person to whom the guarantee is given is called the creditor. Normally, in our case, it's a financial creditor. Uh, Operation creditors normally don't have personal guarantees, with them when it comes to the section 94 or 95. But there is no stoppage. It doesn't say that if you have personal guarantee, you cannot invoke it. OC, FC, there is no difference in this case. So I hope this amount point is clear, that money does not have to come directly into the guarantor's account. Guarantor is only saying that if X person does not do, you can come back to me. Now this much we all know, since we are, you have passed the IBBA exam, I'm supposing, that for any contract to be valid, there has to be an offer, acceptance, and consideration. Now, what is the consideration for the guarantor? There is no consideration, right? Somebody is taking money, somebody is giving guarantee. So the act itself says, and not now, it used to say in 1872, imagine. They say consideration for guarantee is anything done or any promise made for the benefit of the principal debtor may be a sufficient consideration for the surety for giving the guarantee. So this person does not have to get anything independently. So and one more thing before we go deeper. Wherever you have any doubt, please feel free to stop me. We can discuss it. We can move on. So section 127, consideration for guarantee doesn't have to be an independent consideration. Anything done or promise made for the benefit of the principal debtor, which is the CD in our case, may be a sufficient consideration for the surety. Fine. Then there are some illustrations given that, B requests A to deliver the goods. A agrees to do so, provided C guarantees the payment. C promises to guarantee the payment. A delivers the good. This is sufficient consideration. No problem. So I'm not getting into illustrations because then it will be too long. But I hope this one is clear so far. The consideration doesn't have to be independent consideration. 128. It says surety's liability. Liability of the surety is coextensive with that of the principal debtor unless it is otherwise provided by the contract. Now, this section 128, if any one of you have been reading any judgments, you will see that this one is being debated so heavily. Everywhere, court has to say, no, it is coextensive. Banks or financial institutions, whoever has guarantee, they can go after anyone. They can go after CD and PG, only PG, only CD. Imagine it's one line only, right? Only one line is being debated so much. So, can anyone tell me if it is very clear or do we still need to dwell in this? Liability of the surety is coextensive with that of the principal debtor unless it is otherwise provided. So unless it is means you have already confirmed, you have already said that, but till 2008 I am guaranteeing or till 2020 I am guaranteeing. Other than that, sir.
Sir, application can be made simultaneously between before the CD and the personal guarantor both?
Fair enough. One question. Very good. Any other? Single sir, we are saying that this is one line. Imagine, isn't it? And this one line from 2019, we are debating it, even till now. Then, whereas the Contract Act squarely says it is coextensive. When it is coextensive, what is the problem in being simultaneous? Any other viewpoint that it should be simultaneous, it should not be simultaneous? Anyone?
No, I think of late it is even prior to initiation of CARP, it can be only against personal guarantees.
Yes. Where does it say that you have to go with X person first, then only B person? Does it
Exactly.
say that?
No.
It doesn't say that. It only says it is coextensive. Only word is coextensive. Whether I go after B first or I go to my surety, it's immaterial. But obviously, guarantors, they come to court, they say, oh, it has not even started. Company is going perfectly fine. Why should I pay? You give a guarantee. You should have thought it that time before giving the guarantee. You know the Contract Act. Contract Act says if you are giving guarantee, it is coextensive. So whether I go to DRT, NCLT, then they talk about jurisdictions that this jurisdiction cannot be, NCLT cannot entertain. That is procedural. That is procedural, isn't it? But it is coextensive. It should be very clear to everyone's head before we understand what can be the impact. Impact is coming from this section, section 128. Since they give guarantee, it is coextensive unless otherwise the contract is. So illustration was A guarantees to B the payment of a bill of exchange by C. C is, which is the acceptor. Bill is dishonored by C. A is liable not only for the amount of the bill, but also for the interest and charges which may become due. Even this they used to challenge that you had given 100 rupees, we are only guaranteed till 100 rupees. If you are guaranteed till 100 rupees, who will pay the cost, recovery cost, and who will pay the interest? So they are also liable for the entire amount. Fine. Another point which every application you will see whenever you are filing or your advocate is filing, that whether it is a continuing guarantee or not. Now, what is a continuing guarantee? First, let me read it, then we can discuss it. Fine. A guarantee which extends to a series of transactions is called continuing guarantee. So act only says this much, one liner. That's all. It's not even one line. It's 9 words, I think, right? And this continuing guarantee is being debated like I think every order it is discussed. So let us try to understand what it is. Okay. A, in consideration that B will employ C in collecting the rent of, let's say, B's Jamidari, promises B to be responsible to the amount of 5,000 rupees. See, 5,000 because it's a 1872 Act. So 5,000 was a big amount. For due collection and payment of by C to these rent, it is continuing guarantee. Continuing means he is collecting, he is depositing, collecting, depositing, collecting, depositing. There is no time fixed. Till this person survives, till this person is there, it is a continuing guarantee. One example can be this. Guarantees, A guarantees payment to B, let's say a tea dealer, for the amount of 100 pounds. Here, amount is fixed, huh? 100 pound. While giving guarantee, you have fixed the amount, 100. For any tea, he may from time to time supply to C. Time to time. Fine. Again, here the date is not mentioned. B supplies C with tea to value above 100 pounds and C pays B for it. Afterwards, B supplies C with tea for the value 200. Now C this time fails. Now what will happen? Guarantee of A was continuing, but he is only liable till the extent of 100. If the amount was clear and fixed, but no bank, okay, will take a fixed guarantee ever. They'll say this much we have given, any interest subsequent not paid will also be covered under the guarantee. Act says that if it is mentioned, आपने 100 crore दिया है, 1 crore दिया है, whatever guarantee you have finalized, it will be till that. And the third illustration says, now look at the third illustration. Huh? This is different. A guarantees payment to B for the price of 5 sacks of flour. Fine, 5 bori delivery की guarantee है. To be delivered by B to C and to be paid for in 1 month. Now, month is clear, right? Within 1 month. B delivers 5 sacks to C. C pays for them. Fine, this is over, done. Afterwards, B delivers 4 sacks to C. In this case, C does not pay. The guarantee given by A was not a continuing guarantee, and now accordingly he is not liable to pay for that. So whenever as an RP, when you are giving your report under section 99, you also need to check whether this guarantee was a continuing guarantee. It is a valid guarantee. It was not revoked, invoked, and it is valid because it is covered under your 99 report. You're supposed to check that. So continuing guarantee also, okay, this is one thing. Continuing guarantee also means one thing, that suppose you have invoked your, uh, you know, the debt from the CD. CD has defaulted and is under, let's say, under CIRP. But have you invoked your guarantee against the personal guarantor also? Yet. Yes or no will decide here. So let me ask this forum. What do you think? If the corporate debtor, let's say they defaulted on 1st January 2020. 1st January 2020, let's say. Fine. The NPA, the account became NPA on 1st January 2020. Now, till when can I invoke my guarantee of personal guarantee? Can I file an application now on, let's say we are on 12th November 24. It's already how much time? 4 years and
3 years, sir. 3 years.
you can only till what? 1st January 2023 तक हम कर सकते हैं सर? So, Singhal, you are saying we cannot file an application?
सर लिमिटेशन पीरियड विल बी 3 ईयर ओनली जिस दिन डेट ऑफ डिफॉल्ट आपने इन्वोक करी है बैंक गारंटी मतलब कि पर्सनल गारंटी आपने इन्वोक करी है उसके 3 साल के अंदर आपको एप्लीकेशन भेजना
मैंने पर्सनल गारंटी वर्ड ही यूज नहीं किया सर.
ओके
I'm only saying account has become NPA. That means the
डेट
CD
ऑफ डिफॉल्ट ऑफ द
has defaulted.
यस
Date of default of CD is 1st January 2020. Now, please tell me, can I file a PG in 1st January 2024? Yes or no? And others also, please join. I'm sure all of you are senior people there. Many CA we have, CS, Shailesh, Dayalji, Chandrasekhar. I think we have IPs also here. Amrish ji, we have seen Amrish ji, Sandeep Kulkarni. Let's discuss it. See, CPRs वैसे भी सबको मिल जाएंगे, not to worry. At least let's discuss. You can keep your videos off if you want, but let's talk.
I think, sir, it is time barred because 3 years already over from the date of default.
So, according to you also, 1st January 2023 was the last time. 3 years. See, so Limitation Act is applicable on our IBC, correct?
यस सर
Which section says that? Which section says that? 238, right?
यस
Limitation 238A. So there it says it is applicable and 3 years is there. But I beg to differ here. We just learned continuing guarantee. अभी पढ़ा सर, एक लाइन पढ़ी हमने. गारंटी तो कंटिन्यूइंग है. वेयर इज द लिमिटेशन कमिंग? अगर लिमिटेशन ही आनी है तो व्हाट इज कंटिन्यूइंग? इसका क्या मतलब है? सेक्शन 129 का कोई मतलब होगा ना. व्हाई आई एम ब्रिंगिंग दिस एक्ट राइट इन फ्रंट ऑफ यू, जस्ट टू अंडरस्टैंड दिस कॉनेंड्रम कि कंटिन्यूइंग है वो. इट नेवर सेज द मोमेंट सीडी डिफॉल्ट्स योर मीटर स्टार्ट्स. वेयर डज इट से दैट? Does it say that? No, right? So till I invoke the guarantee against the personal guarantor, my guarantee is continuing. So ideally, to recover a debt which is defaulted, I should have around 6 years. पहले 3 साल I will finish my recovery from the CD and I will invoke in the end. Who can say that it's not correct? But obviously there are lots and lots of litigation which is happening only because of this. They'll say your date of default starts on 1st January 2020. I
सर
will say, boss, I have not even invoked. How come it starts?
सर आई हैव वन क्वेश्चन इफ
Yes,
देयर इज डेट ऑफ on the continuing guarantee is 2016 and date of default is 2020 so
yes.
then we can or it is invoked in 2023 as you say then we can file the
Yeah.
application there is no problem but the continuing
That is my
guarantee date is
question. That is the whole idea, sir, of discussion today. That if my guarantee was not invoked, my guarantee was not.
2016 yes
See,
sir
account might be in default, no doubt on that. I have not invoked. I have not, finished my remedy. I gave to ABC company, ABC Private Limited. First, I'm taking from him, let's say. And obviously, it never says that first I have to go to after this person, then to this person. These are separate. Suppose I have not asked the PG, a personal guarantor, what stops me from going after him? Nothing. Whenever you invoke from that day, then it is you give section 8 notice, then it should be 3 years. Now, I mean, it's very easier said than done. But what happens is most of the banks, they used to go to DRT, right, to get their SURFACE action done. So in SURFACE, when you are issuing notice under 13(4), you also do what you do is you give notice to the guarantors also. You make them also party respondent 2, 3, 4, 5, right? Now they are saying that this is an invocation. If you consider it as invocation, then your limitation starts. Now that is a gray area which, depending on which side you are, contesting. If I am from the bank side, I will say, oh, I have not invoked it. It is only a procedural requirement under Surface I. So I had to give it. We have not invoked. We have invoked by Section 8 notice under this 94. So now we are coming in front of you. Hence, there is no discussion of limitation. If you are from the other side, you will say, no, you had given me a notice. That itself means invocation. It
Sir,
doesn't have to be a word.
one more aspect I
Somebody,
will bring here. Sometimes it happens that bankers are assigning the debt to the ARCs.
correct,
See, date is given in 2012. Bankers
correct,
tried from their side, say till 2016, and
correct,
they assign the date to the ARC in 2020.
correct.
In such situation, that limitation will be start because ARC will tell that we got the assignment from 20, so limitation should be start from that day. Or what
No,
should
no, 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 sir. Sir, assignment has nothing to do with invocation. How can it be two things are related? I have this book. I want to give to Pramodji for 5 rupees. I give for 5 rupee, 10 rupee, 20 rupee, doesn't matter. I give with the cover, without the cover, lamination, non-lamination. It's between me and Pramod Ladaji, right? If let's say it belongs to Vinay Singhal how it relates to Vinay Singhal what we have done? He is not a party to this. It's only an assignment.
I can
His
say
gar-
that I purchase with proper agreement as per the law
that
today.
is between you and me, no?
Correct.
Why? It has nothing to do with the third person. Third person should only be concerned with what he had given in the beginning.
Okay.
So ARC is only getting into the shoes of somebody, isn't it? You are getting it by subrogation. Your right of subrogation is that earlier it was, let's say, with Bank of Baroda. Now RCL is having it or whatever. ASREC is having it or whoever. For the guarantor, it does not make a difference. आपने तो गारंटी दी थी ना डिफॉल्ट की. आप अपनी गारंटी पे कायम रहिए. That's all. So assignment, in my humble opinions, need so many codes, right? We don't need appellates, we don't need then higher and higher. So everybody has an opinion. This is an opinion that assignment has nothing to do with the date of default, has nothing to do with the invocation. But yes, if your assigner, they had invoked it earlier and now they are assigning it, and now you are saying that my limitation restarts from the date of assignment because I have got it now. That cannot be hold, right? फिर तो कभी खत्म ही नहीं होगा ना. Then what will happen? I'll give it to Joshi साहब. 3 years he will try. 2.9 years. Then he will assign to another person. Then 3 years, 2.9 years they will enjoy. Then everybody will keep after this person's life. How is that possible? So debt has the limited time life, and that is why your assignment has nothing to do with the invocation or default. I hope people agree, or any other view, then we can still. Single Saab, you are saying something.
No, sir, I am agree with you.
Okay, okay. आपके यहाँ sir, I think fan is working, so
So,
that noise comes. That's okay. Uh, so I hope 126 is the name. 7 is consideration. We have covered sureties liability, which is coextensive, section 128. 129 says continuing guarantee. No discussions till now. I mean, it should be clear. We are fighting for the sake of fighting, but otherwise it's clear. Now, revocation of continuing guarantee. A continuing guarantee may at any time be revoked by the surety as to future transactions by notice to the creditor. So if you don't want to continue right now, suppose if you are advising to personal guarantors, they have given guarantee, they feel that it might go bad, they should go there. They'll say, fine, any future transaction, I am not responsible. I am reviewing it. So in case you feel like that, it's a very bad law, draconian law, uh, which when we know in the second half when we are discussing, we will learn why this law is not a draconian law against them. In my view, it's a beneficial law for the PG. It's an amazing law which they should utilize in case they want to get out of it if it's a genuine failure. But revocation of continuing guarantee can be done after notice. And when you say future transaction means till now, whatever has happened, you cannot take it back. But future, yes, you can take it back. Revocation of continuing guarantee by surety is death. So, I mean, this is pretty obvious. If the death is there, then we cannot say that, this guarantee will keep on, surviving on this. Yeah. Liability of two persons, primarily liable, not affected by arrangement between them, that one shall be surety on others. So this has nothing to do with us. Discharge of surety by variance in terms of contract, any variance made without the surety's consent. Okay, this is also a point where people raise questions, and when we go to the courts, they say that this agreement, whatever has happened, has changed. They even say that rate of interest was changed, so there is a variation. I cannot now, I'm not a guarantor. So any variance made without the surety's consent in terms of the contract between the principal and the creditor discharges the surety as to the transaction subsequent to the variance. If there is any variance, so I hope this is clear to all of us. Any variance, I did not agree. How can I be a guarantor? I am not a guarantor.
Rana Saab, here I have one question.
Yes.
For example, in ABC company, ABR director and X person is coming there, where in a guarantee, if it is mentioned that along with AB, X, who may be the future director, it is mentioned there, maybe the future director will be giving a guarantee. And if X is not appointed at any point of time as a director, so can section 133 will be come into picture over there?
I hope the question is clear to all of us. Any doubt on the question first? Then we will try and explain it. Let's hear it. So the question is, you say X person, when he will be appointed director, he will be the guarantor, right?
No,
Now okay, he's already a guarantor, assuming that he will be a director.
in a guarantee paper, it is mentioned that Mr. X, his name is there, and below the name of the guarantor, it is mentioned that present and future director, or X may be the future director, but X was not appointed at any point of time.
Sir, maybe है ना, may is already there. If you have written maybe, that it itself means it is uncertain. See, guarantee का तो मतलब ही guarantee है, isn't it? Guarantee means we know something for certain. In a contract of guarantee, how can something be uncertain? So, first of all, I don't think anybody must have written like this, a contract where say may not wala portion, because may has nothing to do with his guarantee right now. This person gave a guarantee on the premise that he might be appointed, he might not be appointed. That problem is always there, right? In law, we don't know tomorrow what is going to happen. I may appoint, may not appoint. I am giving guarantee today. Yes, if it was contingent, that his guarantee is only if he is being appointed as director, then it is a different thing. So the moment you say may, it means may not, doesn't matter, man.
So Rana Sahab, in that agreement, it is mentioned that to be appointed as a future director, but that person was not appointed at any point of time. So can that person say that I was not appointed at any point of time?
But sir,
Yes, sir.
for giving a personal guarantee, you don't need to be a director also, I guess.
Certainly,
Absolutely.
Yeah.
paper, if it is mentioned that present and future director or to be appointed director and name is mentioned, but that person is not appointed. So can that person be liable for the personal guarantee? This is a simple question.
Okay. Joshi ji, let me see what other people are also thinking. What do you think? What's your
But, for giving a personal guarantee, as you rightly said, it cannot be may or may not be situation, and you don't need to be a director. You don't need to be a director to give personal guarantee. So whether you become a director or not, that may not affect the guarantee which is given.
Okay, according to you, it should be valid, correct? It should be sustaining. Any other opinions of in this case? Somebody would like to say? Where's our single ji? Single sahab?
हाँ सर, क्वेश्चन इज नोट, मतलब I cannot understand the
Okay,
question.
I'll
If
explain
it is
once again.
not signed by
It's an interesting question.
yes.
He's saying the guarantee was given only on the premise that the person who is giving guarantee will be a director. So he's saying because he is being appointed as director, he's signing it, he's giving his guarantee. So
And
will it be valid in case he is not appointed?
No, sir. Sir,
If that is a premise, then I think if he is not getting appointed, then he may not be become liable.
his guarantee will
Absolutely.
not be valid, sir.
Absolutely.
Because if that is a condition in the contract itself, then he cannot be liable.
So Pramod ji, I hope you got the gist why I framed it differently. Okay. So the premise has to be clear first. Just by saying that he may or may not be appointed, obviously what Joshi Saab said, there it has nothing to do. I can give guarantee to person whom I don't even know. I don't have to be a director, promoter, anybody. No, this thing. But yes, I am giving it only because I am hopeful that I will be appointed a director. And I have mentioned it also in the contract that this because I am a director there. If A is not fulfilled, obviously everything goes away. So the moment premise is not fulfilled, your entire contract falls.
okay.
So premise and the language is very important whenever these kind of dilemmas come into picture. Sir,
So,
this is nothing. Dilemma, much better dilemmas are like last week we were in Delhi NCLT 4 bench, 3 bench. There the guarantor said, I have not signed it. I signed on blank paper. They have put something on this. What do I do? Not my signatures. Problem, though now people are fighting on those. They will say they see my signatures everywhere, different signatures. He's saying this is a bank document. You signed it blank. They said, sir, I never agreed. I agreed because they were supposed to give us some loan. I have signed the blank papers in front of other two directors. And whatever they filled it afterwards, they filled it. I have not read it. So all those things are also coming up. जो आप बोल रहे हैं सर, that is very simple one. कि मुझे डायरेक्टर अपॉइंट करना था, नहीं किया, अब वो तो प्रेमाइस पे लिखा होगा सब.
So
Let's see
section,
that. Yes.
he can take the shield of the section 133 in such situation.
Oh yes, variance. And if there is a variance which is without my consent, then obviously, sir, yes. My consent was only that first कर लीजिए that Pramod ji, I say I am giving a guarantee to the debt, which is let's say 50 crores, which he will use for buying the house. Let's say. Ab Pramod ji has used that money, not 50, but let's say 70 crores to put in stocks. And bank ने भी दे दिया and it was utilized for that way. How am I responsible? I am not responsible. I would have been responsible only when for which I have agreed to. So whenever we say the word variance, variance means I am not agreeing to, I am only agreeing to pala cheez. I am not agreeing to this, or I am not agreeing to this. I am only agreeing to X cheez. Don't put me for X plus delta. X plus delta, I am not worried. Only thing is they will say that if you are not agreeing, you should have told us, we would have changed the surety, we should have changed the guarantor, etc., etc. Uh, that will keep coming. Like in this case, I was telling you, last to last week, uh, court is asking if you were aware that they have forged your sign 5 years back, have you filed any criminal complaint? Have you taken any action? It's not that you are not aware that something is going to happen. Somebody will come after your life. Now everybody knows what is section 94, 95. We also know section 122, 123 in bankruptcy. Right? Somebody is going to come after your life. Have you taken any step? He's saying, no, that we have not taken. If you are not taken that, then how do you take such, defenses that my signatures were forged? Somebody has signed it. I have not signed it. The L is going on the right side. All that stories, they don't hold well. Guarantee का मतलब ही guarantee है, sir. So try to understand guarantee से बचना is very tough. Unless the invocation and limitation is a problem. Only two things which is hurting is invocation. हुई थी कि नहीं हुई थी. That is the only challenge which you can genuinely put against it. So let's say an illustration. When we can variance we can discuss. A becomes surety to C for B's conduct as a manager in C's bank. A is surety to C for B's conduct. ठीक है? B is the manager. Afterwards, B and C contract without A's consent that B's salary be raised and he shall become liable for 1/4 of the loss on overdraft. Right? B, who is an employee, earlier he was manager, now he says increase my salary, but I am answerable for 1/4 incentive types. B allows a customer to overdraw and the bank loses a sum of money. A is discharged from his suretyship by the variance made without his consent and is not liable to make good this loss. Fine? I hope it's clear. Cannot be held responsible. Again, A guarantees C against the misconduct of B in an office, to which let's say B is appointed by C, and of which the duties are defined by the act of the legislature. By a subsequent act, the nature of the office is materially altered. Afterwards, B misconducts himself. A is discharged from the change from future liability under his guarantee, though the misconduct of B is in respect of a duty. So obviously these are different examples, we can learn. What we need to know here is recently also Supreme Court in one of the matter has said this variance, this discharge of variance, defense can only be taken when there is a material difference. I hope you get my point. सिर्फ एड्रेस चेंज हो गया उसका, right? Is not material difference. I was supposed to pay him in Bank of Baroda, but I have given him in Standard Chartered Bank. That is not variance. Okay, so variance has to be material variance. If there is material variance in the terms of contract, then only section 133 can be used by the personal guarantor or guarantor. Fine. And obviously material has no definition, right? So material means has to be significant, which ultimately then is left to the courts to decide. Discharge of surety by release or discharge of principal debt. Surety is discharged by any contract between the creditor and principal debtor by which the principal debtor is released, or by any act or omission of the creditor, legal consequences of which is the discharge of the principal debt. Now, this is an interesting thing. Huh? Can anybody tell why this is interesting right now? Discharge of the surety by release or discharge of the principal debtor. There is a resolution plan. Fine. The CD's debt is finished now, right? Wiped off. Can this be used? 134.
No, sir.
Yes or no? No?
No, no, no.
Why no?
Because it is by operation of law, and such discharge.
Okay. Adiji, you know the right answer. Let us hear other views also. Let's say why this cannot be used. Anybody else? We'll come back to Adi Narayanji. You have the right answer, sir. Just want to get some viewpoint if somebody wants to say. Discharge of surety. हाँ जी बताएं सर.
Resolution plan is not a contract between the creditor and the principal creditor, ना?
लेकिन जब एक ए डिस्चार्ज हो गया तो बी को क्यों रहना चाहिए वहां पे?
बट वो डिस्चार्ज होने के लिए हमारा कॉन्ट्रैक्ट बिटवीन क्रेडिटर एंड प्रिंसिपल डेटर होना जरूरी है ना?
Fair enough. Okay. So Adi Narayan ji and Basin Saab, they
Resolution
are
plan
also
is not a
the-
contract between the creditor and the principal debtor.
Absolutely, sir. So it is not a voluntary thing.
Sir, I have something to say.
Yes, Ms.
If
Bhuvnesh.
the claim received, let us say claims admitted, 100 crore is the claim admitted.
Yes,
The resolution plan is meeting the entire, is giving 100 crores to this bank.
yes,
Then, once the CIR resolution plan is approved, CD is
Yes.
out of this, and
Yes.
guarantor will also be out of it. However, if the resolution plan against 100 claim, only 80 crores is, it was satisfied through the resolution plan, then the
correct.
guarantor is liable for the balance 20 crores.
Absolutely, ma'am. And that is what we call as double dip, right? So one bank cannot be enriched twice. See, if 100 is due, you cannot say कि 100 इससे भी ले लो और 100 इससे भी ले लो, right? We can only say X you will give, Y this will give, X and Y should be 100. Only problem is people were saying you are going for 100 after X also and after the guarantor also. Two people you are putting under insolvency. You may get 150. What to do? So they were challenging this principle, but I think I don't know where's your question, but Bhuvneshwari ji, I didn't get your question. I got your, but you're saying, but
I didn't ask question. I answered.
okay, perfect. Okay. Yeah, sorry, I thought I missed it something. So what she rightly said is 100 rupees is due. If in one, let's say CIRP is going on, one plan is there, the person is getting 100 crore, obviously the guarantor is discharged because the guarantee is only in respect of a debt, of a particular debt. If that debt is satisfied, there is no need to go after the person. But yes, whatever is remaining, you may go after the person for the balance amount. And that is why, in the courts, what is happening just now, we were in one of the SBI case. There was a liquidation has happened, and the bank has got some money, maybe very little. I don't even remember the amount. So we don't know how much was given. Court did not pass the order of insolvency till they know that how much has already been received, because there should not be any double dip. Any double dip is not allowed. If they have recovered, you cannot go after it. So yes, that is right. Discharge of surety. But as Basin Saab had said, and Adi Narayanji was also, started. If it is by operation of law, we cannot hold one person responsible. It is involuntary. It's a process in RAM. But yes, if they are voluntarily getting in between, let's say there is a OTS. Suppose there is an OTS, right? OTS is between two people, right? If OTS is there, then you cannot go after this person. OTS means you have already agreed, whatever is the next amount, only that much is the responsibility. Okay. Now let's go to section 135. Section 135 says, just one sec, dear. Can you? Yes. So sure, discharge of surety when creditors compound. I don't think this is important. Surety not discharge when agreement made with third person. I don't think we need it. Creditors forbearance to show not discharge. Acha, this maybe we can look at. So mere forbearance on the part of the creditor to show the principal debtor or to enforce any other remedy against him does not, in the absence of any provision in the guarantee, discharge. So this is what we have been saying so far, right? That whether I go after principal debtor or not, that is my choice. I can go after you. I can choose also not to go. Like in one of my PG case, the defense which has come up is there were three guarantors. CD went into the insolvency. One of the person has died in COVID. Now the defense is this person is saying, why are you going only after me? Why not the other director who is actually responsible for all this mess? So this is the defense. This kind of defense also they say that why not go after? Obviously, third one you cannot go because the person is not alive. But first is saying why not going after third? And actually, to some extent, if I tell you this little bit of this case, the CD was working perfectly fine. CD had no default ever. CD appointed a person as director, one of the director. He is also a guarantor, right? He appointed the director. Now, this director gave some money for shares, right? In the company, share money was allotted. What happens? He was removed from the directorship. since he was removed from the directorship, he said the shares is my debt. Shares were not allotted to him. So he got the share money, but the shares were not allotted to him. If shares are not allotted, what he becomes? He becomes a financial creditor. So that financial creditor went to the court to start the insolvency. CIRP of the CD under Section 7. That was admitted. That was admitted because there is a default. His money is there, you are not paying him, there is a default. You are supposed to pay him. That was defaulted. Now the guarantee is being invoked. Now the guarantee is invoked. The person I'm saying whom I'm appointed as an RP, he's saying why you are not going after that person also who actually started all this problem. Because till CIRP started and moratorium kicked in, all our payments were on time. We never defaulted on anything. So that defense also they will say, but Section 137, it says creditors forbearance to sue does not discharge the surety. It is my choice. 2 people, 3 people are responsible. I can ask anybody. It is not your call. It's my call. Same way, Section 138, release of one co-surety does not discharge the others. Fine. When there are co-sureties, a release by the creditor of one of them does not discharge the others. Neither does it free the surety, so release from his responsibility to other sureties. I mean, this we are not concerned right now. But one person, suppose one person has died, let's say, you cannot do anything for that. Doesn't mean everybody else is also free. Or one person, let's say his repayment plan has come where we have recovered, let's say, minuscule amount, or say 5 lakh we have recovered out of 10 crores. So only that 5 is reduced. Rest, we will go after them, we will ask them. Same way, discharge of surety by creditors act or omission, impairing surety's eventual remedy. I don't think we need it. Rights of surety on payment or okay. Now this is amazing. Right of surety on payment or performance. This is also called subrogation, right? That if I am paying your debt, then who is your creditor now? If I am your guarantor, bank said, okay, I have paid him 100 rupees, I gave you 100 rupees. Now who is the guarantor? Who's the financial creditor? Now I am the financial creditor. So whatever right the bank had, or let's say the property he had, now that property should come to me. Right? That is called subrogation right, isn't it? That whatever you had, the same shoes I will wear now because I have paid for that shoes. Where a guaranteed debt has become due, or default of the principal debtor to perform a guaranteed duty has taken place, the surety upon payment or performance of all that he is liable for is invested with all the rights which the creditor had against the principal debtor. Now, in our case, in CIRP, you think it is correct or it is applicable?
No, it is not.
Okay. And why it is not, sir?
Because, sir, the resolution plan, otherwise, the SRA which he has committed some amount. So he is liable for that resolution amount. And if he continues to be liable, the corporate debtor continues to be liable for the surety, then there is no end to that. It has resolution plan gets approved on the basis of resolution amount. For that he is committed.
No, sir. I'm talking about subrogation.
So,
So,
subrogation.
I have paid the money. Now that money, if somebody is paying, will they get the right? will they become the financial creditor? So I hope you get this question.
Okay,
Right
I
of
thought it is a personal
surety.
guarantee.
It is personal guarantee, sir. Right now we are talking about the guarantee, right? So
Yeah.
personal guarantor, they are saying if we are making payment, make us. So in fact, one of the case they said, now
Okay.
you make us FC, you make me financial creditor, I'll sit in the COC because I'm making payment.
Yeah, to the extent money has been paid, it will get into the shoes of the financial guarantor. I thought after
So,
the, not beyond the resolution amount. From the resolution
so
amount, it will be distributed and he will be
हम
considered
दोनों.
the creditor.
So my question is actually for both, sir.
जी हाँ,
Post also and pre also.
जी
See,
हाँ,
post we know that there is a section 32A,
जी
right?
हाँ.
Section 32A says clean slate principle, nothing doing, whatever has happened, all go home.
Yeah, including the offense.
Including the offense by the CD.
By the city. Yeah.
By the CD, not by
Yes.
the promoter.
No, not by the
But
promoter.
in case of rights of surety, now whoever is acting as RP is here, can you tell me if one person who is guaranteeing the debt pays off one of the banker, can he sit in the COC
Certainly,
saying that now I have paid?
because he steps into the shoes of the financial creditor, he will have all the rights and obligation which a financial creditor has.
So the guarantor can sit.
Creditor will sit because he is not a guarantor. He is a financial creditor now. He has been replaced.
Okay. Any other views, sir? Other IPs may please enlighten. Basin sir, what's your opinion?
Have something.
Related party, sir.
Okay.
Related party.
Financial creditor, but related party, so doesn't have voting right.
Voting right he may not have if he is a related party. It guarantor not necessary to be related party. Guarantor, it is not necessary that it has to be a related party. I can give guarantee to some other person whom I am not related to.
So Basin sir, what is the answer in
It
this
has
case?
to come within the definition of related party. Then only I will not have voting right.
If he falls within 520, generally 522 पे fall करता है, लेकिन हाँ कोई ऐसा एक exceptional case हो सकता है जिसमें नहीं fall करेगा, तो उसके right of subrogation तो रहेगा ही रहेगा, वो आएगा COC में.
राइट ऑफ सब्रोगेशन रहेगा और वो COC में आएगा गारंटर.
Guarantor देगा.
Okay. Bhuvneshwari ji, what's your opinion?
Yes, let us say this guarantor has paid the bank, and if the CIRP had been initiated at the instance of the bank under Section 7, once the payment is made, in fact, the CIRP has to be withdrawn, isn't it?
No, CD is not paying. Guarantor is paying.
Guarantor is paying. Even
CD
then,
is not paying.
the bank is not there now.
No, Bhuvneshwari ji. The withdrawal is possible only under Section 12A and 30A or upon 90% approval by the financial creditors.
Right. In that case, he will become a financial creditor. And the thing is, if he is a related party, yes, voting right will not be there.
Devvart ji, assignment of loan is also possible during CRP, na?
Yes, assignment of
So
loan is
assignment,
possible.
payment, it is a replacement of financial creditor.
Yeah. Yes.
सर सेक्शन 14 का क्या रहेगा?
मोरेटोरियम क्या करेगा सर? हाँ, ये भी बताओ.
Moratorium is for the company.
Yeah.
Moratorium
Correct.
that you cannot recover money from the company.
Correct.
So here what has happened, it is not the company which has paid. Money has not been recovered from the company. And there will be reason why guarantor has paid to the financial creditor, unless he is asked to pay, unless his personal guarantee has been invoked. He is paying before that. I don't know whether it has been invoked or not.
सर बिना इन्वोक करे कर दो. What's your problem? I know my guarantee is there. I can give away the money. What's wrong?
There are two situations when the personal guarantee has been invoked and the personal guarantee has not been invoked. You know?
Okay.
So
Okay.
when the personal guarantee he has paid against the when the personal guarantee has been invoked, then how he will sit? Then he has paid as a personal guarantor.
Okay.
Situation is in what capacity he has paid.
So far consensus is the moment he has paid the money, you are giving him subrogation right. And make him sit in the COC. As long as he is not related, he can vote also. If he is
Yes.
related, then he will not vote. That's
Sir,
what you
under
are saying?
IBC, subrogation has not been, there is no provision for subrogation in IBC.
Sir, some of our IPs are agreeing on it somehow. So that is why I'm trying to get it.
Sir,
Yes.
I think, you know, if the guarantor has paid, let us say partly, as I told already, out of 100 crore, 80 crore he has paid, the financial creditors liability comes to 20 crore. Accordingly, the voting rate also will be reduced to that extent.
No,
For the bank.
My question was subrogation.
Subrogation is not applicable for the SRA, you know, not for the corporate debtor. Subrogation, it is not that after that SRA will pay to the
Sir, my simple question was, will you put the guarantor who made the payment in the COC or not? Now
No,
that
sir,
is the
I
question.
will not put.
You will not put. Okay. Anil ji, आप रखोगे?
See, if he has paid by invoking the personal guarantee, then he will not become the. If he has paid before that, in place of financial creditor, then he will be entitled to become financial in place of that financial creditor.
सर ये क्या होता है मतलब?
सर सब्रोगेशन तो उसके वैसे ही आ गया ना, दोनों केस में आ गया.
There he has paid because his personal guarantee has been invoked, and the
सर
corporate
ये
debtor
क्या
is not
बात है?
paying.
एक मिनट, अगर पैसे मिल ही गए बैंक को तो अपने आप ही खत्म होगी ना पर्सनल गारंटी तो.
जी हाँ.
तो उससे क्या फर्क पड़ेगा इन्वोकेशन हुआ कि नहीं हुआ? पैसे आने चाहिए बैंक को, इन्वोकेशन से क्या लेना देना है?
आप गाइड कर दीजिए लीगली.
करेंगे सर, करेंगे. सी दैट्स द होल आइडिया.
हम तो मोटा मोटा दो चीजें समझ रहे हैं एज ए कमर्शियल कि अगर ही हैज डिस्चार्ज हिज रिस्पांसिबिलिटी एज ए पर्सनल गारंटर, he might not be able to sit as a financial creditor. But if personal guarantee has not been invoked and he has paid to the financial creditor, then he replaces the financial creditor. Our jurisprudence is that if there is a typical legal status, then you can guide us.
Sir, for last 7 years they are fighting about this only.
Ah.
If we are making payment, let us wear the shoes of the bank. Why not? But let's just, Joshi ji said, Joshi ji, please
ये तो
enlighten
आपने
us.
वो फाइट कर रहे हैं, आपने वहाँ टेस्ट ले लिया.
नहीं sir, see learning में there is no test. All of you are senior to me.
तो आप
But whatever I have learned, I am sharing with you. And in the beginning, sir, I had said everybody has a different opinion. अगर opinion different ना हो तो हमारे को 10 कोर्ट्स की जरूरत ही नहीं है. एक ही कोर्ट हो, सबको क्लियर हो जाए.
नहीं, ओपिनियन इज ओके, बट लीगल फैक्ट्स यू कैन गाइड अस कि व्हाट इज द स्टेटस, लीगल स्टेटस.
यस.
क्योंकि
So
काफी दिन हो गए
currently,
इस तरह के केसेस को हैंडल किए हुए, यू नो.
very good, sir. So IBC subrogation is not there to guarantors or promoters. It's not there. Supreme Court has
to the
clearly
guarantor
said.
also.
गारंटर भी तो सीडी ही है सर, डिफॉल्ट हुआ है अभी. गारंटर नहीं देता तो हम तो वैसे भी निकाल लेते उससे. यहाँ सब्रोगेशन क्या करने आएगा उसको?
अच्छा, दैट इज द लॉजिक.
वैसे भी तो निकाल लेते हैं हम उससे.
हाँ, हम पर्सनल गारंटी
मना
इन्वोक
कैसे
करके
करें?
निकाल लेते. तो देयर इज नो डिस्टिंक्शन.
There is no distinction. Promoter or these so-called so subrogation is only allowed like ARC is taking over from somebody. Assignment is fine.
Yes, sir.
Assignment में
I
होता
got
है.
it. I remember now. A subrogation is not
Yes.
possible. It is not justified
Subrogation
because
is-
he is otherwise also liable. He has
Exactly.
committed.
He is
Guarantor has
otherwise
committed.
also liable. Absolutely.
Guarantor has committed. You know. Yes.
So obviously misrepresentation, concealment, वो सब invalid होती है, that we are
Got
aware.
it. Thank you.
So this we don't need to.
अब सब सारा आईबीसी सब सबकॉन्शियस माइंड में चला गया है. अब केसेस दिलवाओ तो कुछ काम करे.
Sir, one question. Is there any place under IBC where it is mentioned that subrogation is not permitted?
Please tell me where it is permitted, ma'am. Then we will
No,
So
no, it was there, sir.
Or it's
Somewhere.
there, it's permitted or not permitted? Is it there anywhere? I'm asking.
Yes, yes, it is there. I
Yes,
think it was
yes,
there.
yes, ma'am. Yes, ma'am. In fact,
Uh,
many case laws are
yes,
there.
yes, yes.
We will also learn today whether we can extinguish this liability of guarantors in the resolution plan or not. So today we are going to learn on that. Uh, Let me. So this was the Indian Contract Act 1872, which starts from
Yes.
126, which tells you. So you see, my point of bringing this act here is, so at least as an RPs, we are aware these are only one liners, but how they're being discussed in when it comes to the impact on the personal guarantors. Let me start with my presentation. We may take some time in between, after half an hour break, and then that.
अब सब 70% लोगों के पास केसेस नहीं है, सब भूल गए आईबीसी.
तो सर पीजी केसेस तो है ना सर. I know Anil ji is handling multiple of PG cases.
हाँ.
So that is why I think it's a good place to discuss this, sir.
Yeah.
Let us see what is.
मैं
So PG to CD we know, right? It starts at
जी हाँ जी.
section 78, 79,
जी हाँ जी.
where the definition is 94, 95 is our application. So
जी.
94, uh, himself you can go, and 95 is your bankers can go. It can be filed by either of the person, himself also you can file, the other person also can file. In PG, there is no what you call takeover of a company or go to his house and take it over, nothing like that. It's a very simple process where you tell that fine, whatever you can give, tell us. If we are agreeing to it, we will accept it in repayment plan. If it is not there, then we'll go for your bankruptcy. So
It is
personal
not that
insolvent,
simple. As it is envisaged.
envision is very simple.
हाँ.
No coercive action, no coercive steps needs to be taken. No, what you call PUFE application, undervalue, fraudulent, nothing. In fact, even the claims which are not submitted during PG are not extinguished in repayment plan.
No,
If they
here
are
I like to say something, sir. आप complete कर ली, then I will add.
okay. So in PG case, all those who are participating, only those claims are first of all extinguished. The person gives his plan, he say, fine, I had given 10 rupees to this, I was supposed to give 10 to this, 50 to this, 100 to this, but now I have only 20 rupees. You decide how you want to give. My offer is I can give this, fala to somebody. Voting is there, supposed to be a 75%. Uh, in this case, in PG, we still have 75%. It's no
Yeah.
more 66. So
Yes, yes.
75%, if they are agreeing, we will file the repayment plan. In one of the SBI case, I've heard they have taken a very big haircut, like कुछ 500-700 crore का case था, and they have given it away for 4 crore also, 3-4 crores. So people are considering that personal insolvency, the person is going for bankruptcy, उससे क्या निकलेगा? And that is what the actual commercial wisdom comes into picture, which ideally they should be, discussing, and what everywhere our Supreme Court is also saying that commercial wisdom of COC is unjusticiable. It is only for this purpose. Otherwise, top से ही करना था तो Excel sheet बनाते तो Excel can tell me by filter, right? That who is the best. So, Anil ji, you wanted to say something.
हाँ, there are 3-4 things, Devvrat ji. Number one, आपने जो mention किया कि 500 crore, I have a case where the total claims is 1,700 crore.
Okay.
And what he is offering only one asset of 4.65 crore. That's all. Now the expectation of the lenders, they say it was envisaged as a simple, but the expectation of the lenders are, suppose if we believe whatever personal guarantor is saying, then are we not supposed to compare the net worth certificate which was given to the banker at the time of availment of loan and now, and exam and trace the assets. Though asset tracing is not allowed, but the bankers expect whether you have scrutinized the income tax return, whether you have scrutinized the bank statements, whether you have scrutinized the personal balance sheet of the personal guarantor. If all these things are a preliminary work of forensic audit or detailed, not the detailed work, but primarily you cannot believe what personal guarantor is saying on the face of it. Now, another point is that whatever assets he is declaring, the valuation thereof, suppose he says he has got an asset value he is declaring 8 crore, and he is submitting the valuation report also. Whereas actual valuation may be 20 crore, 30 crore. So, should I believe as it is the report given by the personal guarantor? That is one part, sir. Because it is not accepted, and if you do not do due diligence of all these aspects which I have stated, then it is considered that you have not done justice with the job.
Absolutely.
It is not necessary that you do a forensic audit or do investigation or appoint a detective agency. But preliminary work has to be done, and that takes a time, and that is very comprehensive. So unless the information is given by the personal guarantor, you cannot do. The second question is that even after submission of the Section 99 report, the objections are filed, and objection rejoinder, then reply, it takes 8 to 9 months. So that was not envisaged that even after the RP has recommended for the commencement of PRP, and opportunities are being given by the bench to personal guarantors and those who are filing the objection, because the guarantors may be many and the creditors may be many, anybody can file the objection. So these are the two challenges which were not envisaged, sir.
We will come to the challenges, sir. Today we are learning impact of CIRP on PG.
No, आपने कहा कि
So,
simple वो simple नहीं रहा.
no, sir. We all agree, sir. Anyone who is handling PIRP cases also, we know personal insolvency, how much time it takes. I am a PG in one of the case, sir. RP for last 3 years, we have not been able to get it admitted in 94, which is the person himself is saying I'm insolvent.
Yeah.
What else? What more than that you need, right? So all that those issues are there, sir.
Limitation clause. Another thing is limitation clause. The lot of discussion hearing take place on limitation clause also. So,
But sir, in any case, if any of the banks or anybody can proceed against the guarantors, other estates, like for example, his families or his, wives, something like that happening, or is it not permitted? Because
no, sir, the moment you file the application, there is interim moratorium.
No,
So,
I'm talking, for example, if they are proceeding against one particular person, then assets may not be in his name. So he would have transferred that to his wife's name. Or,
correct. That's what is happening, sir. That's what is happening.
In that
actually,
case, what is the remedy? Is that possible for the bank to proceed against?
that is what I was telling Mr. Stephen, that what is happening as per law, the law is not providing for asset tracing. Law is not providing for forensic audit. Law is not providing for detection agency appointment. But if he has done, the banks expect some kind of a preliminary review, whether so that they can take a decision to approve the plan or not to approve the plan. If they do not approve the prepayment plan, then the person guarantor goes into liquidation, bankruptcy trustee. There, the bankruptcy trustee has a right to appoint detective agency. But on what basis bank should decide whether they have to approve at this stage or they should go further for the next stage. That is the reason.
And
So
bankers are not taking call most of the time in personal insolvency because of this reason.
Yes, sir.
They'll say, fine, whatever happens in bankruptcy, we will see, but we are not taking call. So yes, that is happening. But again, it's a commercial wisdom, and that is why we call it wisdom, right? If there is everything on black and white, why we need wisdom?
Sir,
then yes, Bhuvaneshwari.
Yeah. See, with respect to the personal guarantor, in all the cases, I have seen net worth certificates. The bankers are having the net worth certificate detailing the assets which are being, which are available. That's why he is giving guarantee. Bank is accepting. So we can collect that net worth certificate. In fact, I am doing it in some of my cases. And if
Yes.
those assets are not intact even today, if it has been diverted, I think, we should tell during the CIRP itself, we should tell the banker that no major assets are diverted. So if he is giving for 10 crores, 90 crores is diverted. Even if the bank is willing to accept 10 crores, I think we should alert them saying that how can you accept, because your guarantee is not for 10 crores, it's for 100 crores.
Yeah, Bhuvneshwari, there is one catch here. You know, the guarantee, that net worth certificate was given say 12 years ago, and the latest certificate is coming today. In 12 years, you cannot allege it has been diverted. He can say he has sold the assets. He's not having those assets, and by selling the assets, he has discharged some liabilities. So we cannot say that he has diverted. The personal guarantor has diverted the funds. Only thing we can say, these were
Unless there
assets.
was a charge created on those assets.
Even the charge was created, suppose he had, personal guarantor had assets. He has sold the asset and he has paid the loan from that assets. So we cannot say he has diverted unless it is proved that he has diverted, undersold, he has done some
नहीं सर,
profit direction.
अगर
Whether it
मेरा
has gone to, sorry,
अगर
whether
मेरा
it has gone to the same banker against the liability created, that we can look
Absolutely.
at, isn't it? If it has gone to
Absolutely.
the banker, I agree. But if it has gone to some other liability to somebody else, and when he has given the net worth certificate, he is saying these are my assets and I am giving guarantee.
Yes, yes.
Whether the
No,
assets are
Bhuvneshwari ji,
mortgaged or not.
Bhuvneshwari ji, we have to differ here a little bit, because when you took a net worth, it does not mean he is giving that asset to you.
Yes.
Unless he has committed that these assets you can have first charge,
No,
then only you take
then.
it, then only you can hold that person responsible. And that was a problem with our system. They said that we will this person has a heavy net worth. Let's say 10 properties were there at that time.
No, then it is a
Just
personal
after
security.
getting the loan, they will straight away take it out next day. They'll make a trust and finish it. So it is bankers' problem, not our problem at this stage. And in fact, as Anilji was saying, during insolvency resolution, we do not have coercive steps, but just to take an informed decision. If you are appointing a valuer to say, okay, fine, he's saying it's a 4.5 crore property, whether it is 4.5 or 7.5, we want to check it. I think it's still worth it. 20-25 हजार रुपए लगा के, if you are able to get a independent view also on that, we should be doing it. I do in my cases.
No, but Devvart, there is a challenge here. Can RP go for valuation on its own or at the recommendation of the creditors? Because
always
in
creditors, sir. Always creditors.
In the
Always.
CRP, you have to appoint valuer.
Here it's a decision of the COC, sir.
COC.
Yes,
Though you
yes.
know, so see what you were saying is very right. If that asset has been given as a security, that is a different issue. Charge has been created. That is a collateral security with the banker.
Then
But
Bhuvneshwari ji was saying na, ki then
हाँ,
siphoning off, etc., will come into picture. But otherwise, Bhuvneshwari ji, if they have not created a charge, because if it is a charge created, still sold, then it is a fraudulent thing.
no, that
Straight
is
away.
illegal. Without
Then is
getting the charge
illegal.
released.
Absolutely. So वो तो
And
वैसे
I
भी
think,
नहीं होगा.
basically, it's a problem with the bankers. If they are taking the net worth certificate and taking guarantee without creating charge on those properties. In fact, it has happened in one of my case. One guy gave
every
50
case.
50 acres of land. Net worth certificate. Afterwards he transferred it to his own wife, who is not a guarantor.
Absolutely. Madam, you are surprised to know that now every guarantor, I am busy. Okay, let me not say every guarantor, but most of them have 2 or 3 wives now. And I am facing this challenge that whom to go after. So in fact, ED is finding in its own detail that, first wife they have transferred this much, second they have transferred this much, whom to go after,
But
like which one?
Devvrat, as per Indian Marriage Act, can
Sir,
somebody have 2 wives?
They cannot. So, sir,
then?
divorce करना कितना problem है? Mutual divorce is very easy. So, on paper they are divorced. They are separate, totally separate, no problem. On paper they have trust. the trust is in the name of the son, then son will file a case against the father only. He'll say, how can he is giving? Okay, in one of my case, they gave the shares of the trust as collateral. So the trust was in the name of the minor son. Minor son, after he became, adult, he filed a case on all the banks, and the father, saying this is for my benefit. How can the property of trust be given as a collateral, as a guarantee? This could not have been taken by the bank. So some of the banks, they said, sorry, our mistake, we are releasing it. Some are still fighting it. So all that is happening, that is fine. So let's come back to our session today, what we were doing. Our session is impact of CIRP on the personal guarantors. Fine. So, okay. So these definitions, I guess we all know, but we'll just go through them pretty quick. Section 5 of IBC, personal guarantor means a direct debtor who is a personal guarantor in respect of whom guarantee has been invoked and is unpaid in part or full. Right? Full तो है ही है, even if part, and that is where it covers. Even if resolution plan you have recovered something, doesn't mean it goes away.
Yeah.
Even if 1 rupee is remaining, it is covering that. Section 126, we have already learned what is a contract of guarantee. Though the contract still says the guarantee can be either oral or written. Oral की कोई वैल्यू नहीं है हमारी लाइफ में, सो इसको भूल जाते. 79 of the IBC says debtor includes a judgment debtor. Section 3 of IBC, debt means a liability or obligation in respect of a claim from any person, and both the debts, financial as well as operational. Qualifying debts, excluded debts, I hope all of you are aware. In case you are not, I'll go through it very quickly. Qualifying debt is amount due which includes interest
me,
or
sir.
any other sum. Yes,
Are
ma'am.
you sharing the screen? It's not visible.
My screen is not visible.
But I can see.
Visible,
Yeah,
sir.
it is
It
visible.
is visible.
Oh,
हरमीत जी दोबारा
okay.
स्टार्ट करना पड़ेगा. Okay.
Only thing, kindly go to presentation mode, sir.
Okay.
Then it
That
will be
will-
bigger size font.
PPT.
Okay. Allow. Is this okay now? Better, huh?
Yeah, better. But you
No,
can make
actually,
the font little better.
actually,
bigger.
I will forget that how many slides are remaining. So,
If
okay.
you
So
discuss that, the slides will not be covered. Only discussion
Absolutely,
will be
sir.
over.
So slides we can share, there are thousands
Ah,
of material in the world, but
yes,
discussions don't
is more
happen. So,
important. Yeah, clarity comes from the discussion, from your experience. When we share the
correct,
experience, you know.
correct. So qualifying debt is if it is not an excluded debt and it is due in now or very close, fine. Also, the fresh start process has not finished in last 3 months. So fresh start has not been notified as yet. So this does not cover. Excluded debt, there are 5 debts from the guarantor which are excluded, which is liability to pay any fine imposed by a court, liability to pay damages for negligence, nuisance, or any breach of statutory legal obligation, maintenance to any person. So now this is also being used. I was talking about, right, the divorce thing. So they take heavy maintenance. So wife has said, this person will give me 5 lakh per month. सारे पैसे तो वहीं चले जाएंगे. This is any which way is excluded debt. वहां से वैसे भी कवर नहीं हो सकता. Liability in relation to a student loan. Student loan is also not covered. And any other debt as may be prescribed.
Here, I would like to say something, sir.
Yes.
In our practical experience, the repayment plan submitted by the person guarantor is seeking waiver and exemption in respect of profit addiction, in respect of
Correct.
legal cases filed for the checks which are bound under section this 138 negotiable instrument act, and other legal cases which have been filed by very subsidiary companies, other companies, for the funds taken as subsidy or for other reason not complied with. So there are several cases which were going on against the competitor where the personal guarantee is also involved. So he has
Correct.
sought the waiver and exemption of all these things.
Correct, sir.
So there is no
But
clarity. There is no clarity here
and
in
sir, there
the.
is a clarity. Section 79 clearly said that these cannot be included. These are excluded debts.
Where it is a
Sir,
proof of transaction,
section.
where it is.
No. That's what I'm saying. Section 79 talks about if there is a fine by the court, it cannot be removed. Proof transaction is an analysis which the bank is still needs to do. So they are saying, don't get into that. We are giving you a repayment plan. So repayment plan is essentially what? OTS only, isn't it? OTS that fine, this is one-time settlement. One-time settlement can be over a period of 2 months, 3 months, whatever. So one-time settlement. Now you will not go back into my books, etc. This was my guarantee. I am getting my guarantee free.
No,
Whatever
Devvart ji.
property I have given.
Can I give? Because I have to give a report to under section 106 to NCLT that
Yes.
this plan is this repayment plan
Compliant.
is IBC compliant. Now
Correct.
the personal guarantor is seeking exemption of all these things. Can I give? Can I say that yes, give him?
Sir. Okay, let me come to. So
He's seeking discharge.
He's seeking discharge even during the CIRP from
No,
the CIRP. So he's
CIRP is
mixing two
over.
things.
CIRP is over. Resolution plan has been approved. The SRA has taken over. You know.
Right.
But there are legal cases which are going on against the company for the money of fraudulently diverted or misused, not only by that company but so many other companies where he was director.
That is what I'm telling you, sir. So that PUFE arised because of a CIRP proceeding.
Yes.
Correct. That has nothing to do in this proceeding in personal
No.
insolvency.
But if
So
there is a
personal
decision,
insolvency.
if there is a
Yes.
decision by the
Yes.
NCLT or
Yes.
special court that he has diverted, so there will be recovery against him.
Absolutely.
If he has done, suppose he is punished, for
Yes.
fraudulent transaction, he can be punished also. For
Yes.
preferential under action, he can be
Yes.
requested to reinstate the position.
Correct.
So he is seeking waiver of that.
Okay. What the forum says, can we include that?
Yes, sir, we can include that in the qualifying.
No. So you are saying PUFE transaction exemption, if he says you remove my PUFE thing, you will put in the plan and you will get it approved, is it?
Now, what will you show as RP? Will you endorse the plan?
No, sir. PUFE transactions are not to be excluded.
And he is a director or partner in some other entity where some fraud has happened and his name is there. His case is going on. Recovery can happen from that court also. Can we give him exemption? His cases is going on.
Adi ji said no. Anybody else? Any view? Bhuvneshwari ji?
Yeah. See, we are concerned only about our CIRP.
No, PIRP. It is not CIRP, it is PIRP.
Same thing. We are concerned about our PIRP, correct?
Our PIRP, only with respect to that. But anyway, if the COC is accepting the resolution plan, then he goes scot-free.
No.
Ma'am, फिर तो कोई problem ही नहीं ना. We are not talking about CIRP now. We are only talking about personal insolvency.
Personal insolvency.
So he's putting a plan, repayment plan. He's saying, don't go after me in PUFE.
And
You
PUFE
have to
and many other criminal proceedings which are going on.
But here in personal insolvency, where is the PUFE? It's not there.
Exactly. So PUFE is of CIRP.
Correct.
But he wants to get it removed here.
No, but it is not legal. It is legal anyways. Such a plan may not be approved by NCLT also.
Yes. So what we have done, what is the solution in that case, Devvrat? For RP, how to handle?
Sir,
Because
it is a non.
he's
It's
not ready to revise the plan. We told him, withdraw. He
sir,
said, no, I will not withdraw.
फिर तो 106 की you'll finish the proceeding and within 3 months you go under 121
No, no. उसमें क्या
bankruptcy.
है? उसमें what we have done, we have considered, taken a legal opinion and taken a considered view that these are the exemptions and waivers he is seeking discharge, for which law is not very clear. We leave it to Honorable NCLT to decide what to do. I'm not
So-
taking a decision. I'm not, because I cannot, only with respect to the liabilities which are legal, which are established, for that I have got a claim, so that, okay, it is accepted. But all those liabilities, I'm leaving it to Honorable NCLT because there is no clarity.
Sir, there is
My
an affidavit which not.
In my
Yeah,
view,
please. Yes.
in my view, if the resolution plan is submitted under the personal insolvency and if COC is accepting it, fine. But at the same time, if there's a PUFE under the CIRP, I think that should continue. And the NCLT has to take a call. These two cannot be linked to personal insolvency, and that's the money diverted. Whereas
Ma'am, but
this is a
as a-
liability created because of his guarantee thing.
No, ma'am, my concern is that when I am submitting my report on the repayment plan, what should I write? Honorable bench will ask me, on what basis you are giving, recommending discharge?
Sir, let us say all these days, the same RP was not allowed under CIRP and personal insolvency. And let us say in this case, I don't know about the CIRP. What is his liability? What is it? I don't know. As far as the personal insolvency is concerned, as far as as on today, these are the details of the assets lying in his name. And accordingly, he is submitting the resolution plan.
No, ma'am,
Yeah.
he is submitting the copy of the petition. The amount, what will be recovered from him is not known. He is saying amount not known, but he is seeking exemption. So I am RP, he is seeking exemption. I have to report to NCLT about each creditor.
Yeah.
Absolutely, sir.
So I cannot.
Sir, we can move on to the next
Yes,
point.
let's move on to the next point.
No.
So, Anilji, we'll try and conclude it here in 1 minute. That's all. This PUFE will not be exempted, but you don't want to take a call. You have sent it to NCLT. I think there is no form H like this, which is a compliance certificate which RP has to give. In my view, at times they might bash you also, saying, "Ke, how can you put such things to us?" That is a risk, sir, you have to take, and
No,
you
no,
have
no, no,
already
no.
taken. So,
Here, let me correct you, Devvrat. We requested him to withdraw and submit the revised plan. He said, I will not, I will seek. You cannot stop me from seeking exemption. It is my right to seek exemption. I am seeking.
ठीक है, sir.
So, what should I can't tell him, no, you
So
submit
as
that.
long as
I can guide
COC
him.
is voting, sir, COC is voting on it, तो ठीक है. End
No,
of the day,
COC
their
will come
commercial
later, sir.
wisdom.
COC will come later. First,
अच्छा,
I
you're
have to,
talking about 106, पहले
I
first
have to
report.
deal with
Okay.
NCLT also, na?
Correct.
So,
So you only have to say whether it has a fair chance of approval or not, right? That report you must have submitted.
And what is my opinion on these kind of waiver and discharge he is seeking for? Though I have advised him not to claim this waiver. He doesn't want to listen.
Fair enough, sir. Fair enough.
That is my submission. So let us conclude in this way, because he said he has a right to seek discharge. Let court say no.
ठीक है, sir. So excluded debt and excluded assets. Assets we know 10 lakh and 20 lakh house, and rest is an insurance, etc. 1 lakh rupees.
One doubt I have, I don't know whether I have
Yes.
gone to some other world during this process, I don't know. When it is legally allowed as excluded debt, why are we contesting on that? I'm not getting Anilji's point.
No,
No,
excluded
which
debt.
one, ma'am? PUFE is not decided yet. It's not
PUFE
a
and legal proceedings, criminal proceedings against the personal guarantor.
See, excluded debt, there is no fine imposed as yet.
Ah.
Right? So if there is a fine, it cannot be excluded. If there is a
Yes.
damage, cannot be excluded.
Yes.
Maintenance cannot be excluded.
Okay,
Student
because of
loan,
UFA pending, you are talking about this.
because it's
Yes,
still
ma'am.
pending. He is only asking that don't pursue it.
Okay.
Just drop it. That's all.
No,
So
he
let
is
his,
saying that whenever it is decided, he will not pay anything.
सर
Give me
बात तो एक ही है
exemption.
ना, बात तो एक ही है, परसों ही मत
हाँ
करो, अपने आप ही खत्म हो गया. सो
हाँ
फिर कोर्ट में जाने का मतलब क्या है, अगर वो ही विल नॉट पे एनीथिंग. सो इज सीओसी अबव एनसी कोर्ट? ये तो हो
So
ही नहीं सकता ना सर.
he is seeking. He is not going to COC. COC will go to later. COC is concerned about the entire plan and what they are
समझ
getting. You know, I am concerned about
हाँ,
legal status. Here NCLT will deal with legally.
डन सर. हम आगे चलेंगे सर, थोड़ा सा क्विक वाला
Yeah.
करेंगे
So
आज.
he is not paying anything to prefer transaction.
Fair enough, sir. So, 5 stages of insolvency. Defaulter is when default has occurred. Potential insolvent when we have not filed it. We have just filed it. यहीं पे हमारा 96 का मोरिटोरियम शुरू हो जाता है. Then we call insolvent where insolvency is admitted but repayment plan has not been sanctioned. Undischarged insolvent when the plan has been submitted and it is under implementation. And bankrupt is when a person is adjudged as such. So court has to declare the person as bankrupt, then the person is called bankrupt. So this is not much of an importance. Two type of moratoriums we know, 96 and 101. 96 is an amazing moratorium which many personal guarantors are enjoying. If the banks are not filing, they file themselves so that it can be heard of. So interim moratorium from the date of filing, and from the date of filing, then there was a issue that they will file it, but they'll not remove the defects, etc. Then some court said that it will be from the date of defect clearance. But again, then some courts said that no, fine, it is from the date of default. So interim moratorium is from the date of application. No time limit is specified. Any pending legal action, etc. applicable. Final moratorium, when order under 100 comes, then 101 is the moratorium section. Similar order, 180 days it is allowed. Rights of secured creditors, either they have relinquished the security, not relinquished the security types we have in. If somebody says, no, I want to be out of this proceeding, they can be out of this proceedings also. Let's understand the impact, because that's what we have gathered here for today. Now, can a guarantee be invoked before claiming the same from the corporate person? Right? We have not asked the corporate person, that means the CD. Before that, can I ask for it or not? In this case, here, NCLAT Delhi in Vishnu Kumar Agarwal versus Piramal Enterprise, there's a 2018 case. They said guarantee can be invoked before claiming the same. We have learnt in the act, right? Co-extensive. Co-extensive means किसी से भी पहले हम मांग सकते हैं. Same view is by the NCLAT Delhi. Creditor is not bound to exhaust his remedy against the principal debtor before suing the guarantor for the debt of the principal debtor. Once an application under Section 7 is admitted against any one of the CD, be it principal, borrower, or the guarantor, a second application by the same FC for the same set of claim and default cannot be admitted against the CD or the corporate guarantor. So PG के केस में they said कर सकते हैं, CD के केस में नहीं कर रहे हैं in this case. सो सेम सेट के लिए आप 5 कंपनियों को एक साथ इंसॉल्वेंट कर दो, वो नहीं हो सकता. पर्सनल गारंटर में कर सकते. जुरिस्डिक्शन, वी ऑल नो दैट आवर कोड 2-3 साल तक, इनफैक्ट मैं तो कहूँगा अभी भी बहुत क्लैरिटी नहीं है साहब कि विच इज आवर राइट फॉरम. सेक्शन 60, but more or less nobody goes to DRT now, everybody goes to NCLT only. Section 60, corporate debtor, personal guarantor for insolvency resolution and liquidation. Pecuniary jurisdiction is NCLT. Appellate is obviously NCLT Supreme Court. Territorial, registered office of the CD. That is main criteria. If CIRP is going on, CIRP is not going on, then we go to the corporate guarantors residence, wherever he is residing, that will become the NCLT. This in turn create a link between insolvency resolution and bankruptcy process. And let's say whenever the CIRP starts of the CD, then that same matter will be transferred in case it is in some other NCLT. So that same process can happen in one of the in the single NCLT. Same set of default. Fine. Here we'll just remind just now, Bhuvneshwari ji had mentioned earlier same RP was not allowed. Now same RP can be RP, CIRP. He can do CIRP also. He can do the personal insolvency also. It is allowed, right? In I think 31st January, this notification had come. Same person can be appointed in both the matter. Lalit Kumar Jain, I'm sure you must have heard so many times. In this case, Supreme Court sanction of a resolution plan and finality imparted to it does not per se operate as a discharge of the guarantee. ललित कुमार जैन में कह रहे थे नहीं होगी, ठीक है? So just even if you don't take away too many things from here today, just pick these few things which I'm bringing. Supreme Court in this Lalit Kumar Jain, which was a long fought battle, they said sanction of a resolution plan does not per se operate as a discharge of the guarantor's liability. Right? So Bhuvneshwari ji, we said 80 अगर चली गई है, 20 अभी बाकी है, so that 20 will still remain. Fine. As to the nature and extent of liability, much would depend on the terms of the guarantee itself. However, HC has indicated time and again that an involuntary act of the principal debtor leading to loss of security would not absolve a guarantor. So this was the reason. Involuntary act, right? It was a operation of law. It was a process in RAM. So we can't do much and there is no discharge. In this case also, Maharashtra State Electricity Board case, liability of the guarantor in case where liability of the principal debtor was discharged under insolvency law was considered, it was held that same thing. I mean, it cannot be discharged. There is no discharge under 134. 134 we have recently covered. In Lakshmipat Surana case, another important judgment which was there in 2021, expression corporate debtor हो गया. Upon harmonious and purposive construction of the governing provision, it's not possible to extricate the corporate person from the liability arising on account of the guarantee given by it. Similar, liability of the guarantor is coextensive with that of the principal. Every day they challenge and every time it is clear that it is coextent. Corporate debtor to pay off the debt which had become due and payable. In Athena Energy Ventures, in Anklet, they say if two applications can be filed for the same amount against the principal borrower and guarantor, keeping in view section 60/2 and 3, application can also be maintained. That means simultaneously, no problem in continuing both the cases. IBC does not prevent this simultaneous going. And they also said that under the contract of guarantee, it is only when the creditors would receive the amount, the question of no more dues or adjustment would arise. Fine. Dilip Jiwar ji ka case was this one. Dilip Jiwar ji ka case, there were around, I think, 400 applications which were clubbed into it. This was a recent judgment by our recently retired CJI. Here, the role under if any one of you have not read it by any chance, just go through this once. You will understand the personal insolvency altogether. Role under section 99 is to gather relevant information on the basis of the application which has been submitted in 94-95. So, Ajay, this was about a report of corporate of the RP. Now, in this case, RP gives 10 points. There are, under section 99, there are 10 points which RP has to say whether he has asked, he has, checked all the points. As long as they are fine, though Anilji would disagree that, court still gives 9 months and 10 months. I have seen in some of the cases they admitted second application also, like second date also. So two of my cases, they were admitted, you know, within 2 months, and it also may take years depending on, what kind of situation.
No, sir. Devvrat, it depends upon the objection, if any, filed. If there is no objection filed, then it will be admitted upon submission of a report. If there are objection filed, then you have to submit rejoinder. Then there will be pleadings, arguments. That's it.
So luckily Hyderabad NCLT was fast enough and they did it within second one, even though there was objections.
It
So
depends.
correct. I
It
agree, sir.
depends
I
because
agree. Depends on the kind of, yes,
each hearing is for 1 month, 1.5 months, then what will happen?
absolutely.
Sometimes the adjournment is taken, sometimes paucity of time. In some of my cases, two hearings could not be taken because of paucity of time.
Yes.
So you lose
That is
time on that count
that
also.
on that account, sir, no
Yeah.
one can help right now.
If there is
So
no objection, it will be.
Section 99 report is we are not adjudicating. There we are only helping as an officer of the court by tick marking that we have followed the procedure and what the RP opinion is. Fine. Subrogation, we have learned in between that Section 140 of the Intent Contract Act, right of surety on payment of performance where a guaranteed debt has become due or default of the principal debtor to perform a guarantee, surety upon payment of all that, he becomes that, right? So this we have learned.
Devvrat, one
Yes.
point I want you to focus on limitation, because in my all applications, bank either hurriedly or ignorantly or by
Yes.
mistake has not treated the aspect of limitation.
Yes.
And the
I know
main
that's
objection which is coming
is
by the
limitation.
personal guarantee is limitation. And
Yes.
to deal with
Yes.
it becomes a cumbersome process. In most of the
Absolutely.
cases, it is limitation which is being challenged.
Every case it is, sir.
Yeah.
Every case limitation
So,
is the first thing which needs to be
so
challenged.
the lesson learned is that in Section
And
99 report, we should deal with limitation very clearly before recommending for the PRP commencement.
okay, just to inform you, sir, in case people here, if all are not advocate, even if it is not challenged, courts has to look at the limitation, even if it is not challenged.
So that is
So
what I'm saying.
limitation is something which RP should definitely look at, whether it was correctly invoked, whether it was, see, normally even if it was wrongly invoked, I don't foresee, where an RP appointed by the bank will say no, it is in limitation, until unless it's, bluntly on the face of it. Otherwise, no bank will appoint you as a RP. So I don't know how are you going to tackle that problem, sir. But yes, we are supposed to, as a neutral
Yeah.
party, we are supposed to inform that, what is your take on the limitation.
But we do respect, initially, in my initial reports, I was not very clear about the 99, this limitation aspect. It was not dealt with as seriously as it should have been dealt with.
Absolutely.
Let me admit, So,
Agreed, sir. Agreed.
yeah.
So Devvrat, can we give some focus for the limitation? How to calculate, how to count or trigger points for the limitation, specially?
Sir, अभी 1 घंटा है sir हमारे पास. No, certainly we will. Let's keep that last 15-20 minutes for this only. Maybe this PPT will cover lot of that aspect also. If it
Also, one more.
doesn't, last 15 minutes we'll only keep for that. Fine.
Yes. Also, one more point here. If any RP is appointed by the FC, so can the CD take the stand that he is appointed by the FC from their empanelment list, and that the reason they are giving the positive report that case has to be admitted. So if such types of objection is raised, whether it will be valid or to what extent?
They are never accepted, sir. They are never accepted. You are right. Every CD has same set of objections. They'll say, आपका तो empanelment है, how can he deny? Which at times we also agree, right? If you are appointed as RP, if the application is filed through you, why will you say no to it? The moment
Correct.
you'll say no to it, your appointment is gone, right?
Correct.
So yes, that is there, but as an see, you are an RP. You are an RP because of what? Because you are an independent, impartial person. You are supposed to say. और वैसे भी पर्सनल इंसॉल्वेंसी में सर 25-30 हजार रुपए फीस मिलती है. सो बेटर यू स्टिक टू द करेक्ट स्टैंड ऑफ व्हाट द लॉ इज, बिकॉज अगर आप गलत भी बोलेंगे तो वो एडमिट नहीं होने वाला है,
Correct.
राइट. ओनली थिंग इज you have to give your opinion or why it should be admitted, should not be admitted. Still, if you say that fine, this is not clear, see at best in my opinion, right, you, मुझे नहीं लगता आप उसे रिजेक्ट करोगे, ठीक है. नो वन ऑफ अस विल डू दैट, राइट. सो बिकॉज द मोमेंट यू विल डू इट, बैंक ही आपको ब्लैक लिस्ट कर देगा. सो यू विल नॉट से दैट, यू विल से फाइन, दिस इज नॉट क्लियर टू मी, लेट द कोर्ट टेक अ कॉल ऑन दिस. ये तो
But
बोल सकते हैं ना.
court expect answer should be yes or no. Vaguely
आई
court
आई
should not
एग्री
expect.
सर, मैं बिल्कुल आपकी पॉइंट समझ रहा हूँ, बट डिलेमा इज कि हम करें कि ना करें. करेंगे तो मरे, ना करेंगे तो वो पकड़ेंगे.
No, no,
सो
no,
इस
Devratji. Here, I don't think bank will take any action against you if there is a clear-cut case of limitation not covered. So you
सर,
should
इफ इट
say
इज
no.
इफ इट इज ऑन द फेस ऑफ इट, तो आप
Yeah.
वैसे भी आपको बोलना ही पड़ेगा.
हाँ
लेकिन अगर वो नहीं है ऑन द फेस ऑफ इट,
हाँ, if there is
तो यू
a
हैव अ
हाँ
ग्रे
अरे
लाइन है, तो आप
हाँ
उसे
ग्रे लाइन है, if there is a date of invocation में कोई प्रॉब्लम है तो आप उसका चांस ले सकते हो, भाई आप देख लो उसको. I have
सर
taken this stand.
सर बिल्कुल ब्लैटेंट तो उनको भी पता है कि चलो गलती से फाइल हो गया था, अब क्या करें, तो नहीं हो सकता, विच इज ओके.
हाँ नहीं, मैं आपकी मीटिंग से पहले ही वी वर डिस्कसिंग द लिमिटेशन इशू, वहाँ गलती से बैंक ने फाइल किया हुआ था इंसिडेंटली, सो दैट्स व्हाई आई एम टेलिंग यू, यू नो. सो नाउ वी हैव टू
आई एम अवेयर ऑफ दैट केस सर. सो
आपको ये आईबीसी वो पर्सनल इंसॉल्वेंसी पढ़ा ही हमने आपके साथ था.
आई एम अवेयर ऑफ दैट केस सर. तो
ये
ओके.
हमें पर्सनल इंसॉल्वेंसी कहाँ पता था, आपने ही पढ़ाया था.
थैंक यू सर, थैंक यू. सो राइट ऑफ सब्रोगेशन हम पढ़ चुके हैं. सो समबडी वाज आस्किंग मी अबाउट राइट ऑफ सब्रोगेशन, ये कहीं लिखा है कि नहीं लिखा. आई थिंक भुवनेश्वरी जी वाज आस्किंग. सो इन दिस ललित मिश्रा एंड अदर्स केस, Supreme Court had given this, you know, law. It is not the intention of the legislator to benefit the personal guarantor by excluding exercise of legal remedies available to recover legitimate dues by enforcing so and so. While considering the resolution plan, the creditors focus on resolution of the borrowers in line with the spirit of IBC. Present application has been preferred by promoters. But this was the case. So, Bhuvneshwari, you were asking, Lalit Mishra case, the right of subrogation was discussed by Supreme
Right.
Court, where they said it is not allowed. Impact on liabilities against Negotiable Instrument Act. Negotiable instrument is our check bouncing thing, what we call, right? Section 138 normally. So in this, Ajay Kumar Radhesham Goenka case, TCI Tourism and Finance Corporation, 138 cases will not be, uh, dealt in when it comes to our personal insolvency. What is resolved is only the company and not the personal penal liability of the accused. After passing
इम्पोर्टेंट
of
है
the resolution,
ये केस, इम्पोर्टेंट है. इट मीन्स ये सुप्रीम कोर्ट का है.
हाँ सर, ये सुप्रीम कोर्ट केस है. ये वैसे इट्स अ वेरी सेटल्ड लॉ, एवरीबॉडी इज अवेयर कि भैया criminal liability, see, check bouncing is a criminal liability if it is under 138, not civil. So it's a criminal liability which cannot be absolved. After passing of the resolution plan under section 31 by the AA and in light of the provisions of 32A, which is our clean slate, criminal proceeding against under section 138 of the NI Act shall stand terminated only in relation to the CD if the same is taken over by a new management. Section 138 proceeding in relation to signatories directors who are liable, it's not exempted. Also, it should result in the change of management. Then only it is not, then only it is clean slate. If the company itself takes it over, then
No,
it
no.
cannot go away.
Very true. ये
Fine. So
this case is very important. आप भेजेंगे
yes,
ना इसकी ये शेयर करेंगे ना अपना
I,
presentation.
I will certainly share with the
हाँ, तो I
ICS.
can convince now the personal guarantor, please don't seek exemption. You know.
हाँ, ये तो हो ही नहीं सकती सर. This is
But he
very
is
clear.
seeking ना.
It's a 2023 case. You
Hmm.
can. The reference is also mentioned. In fact, in case you just want to talk, 32A जो clean slate principle है, that only is applicable when there is a change of the management.
That we
If the
know.
promoter
Yeah.
management is same, it will
Yeah.
not be of
या उनका even FIR में भी नाम है, they will not be. Those who have awaited the
there.
crime also, they will also not be.
But sir, I have a slightly different opinion here. I'll tell you why. Section 138 is end of the day a money matter.
Hmm.
So when the money matter is there, the person says, I am going bankrupt. Now I genuinely, if I had money, then why will the court call me bankrupt? I don't have money. That is why I'm bankrupt. If I'm bankrupt, what good it will serve by putting me in the jail? You put somebody in the jail to coerce that person to pay the money. Now, even if he wants to, he cannot pay because he's bankrupt. His
No,
property is being managed by the bankruptcy trustee. How can he
no,
even pay, even if he wants to?
I am not a legal person, but whatever little I understand, it is considered as a criminal offense because check has been given the status of currency, you know. And if he has signed a check knowingly that he will not be able to honor, there is no balance. So he has disrespected the currency. So that is the reason for criminal proceeding, not a recovery.
मैं लॉ
I am
पे
not
फाइट नहीं
I am
मैं
not
लॉ
a
पे सर मैं
हाँ
लॉ पे फाइट नहीं कर रहा हूँ. आई एम ओनली
हाँ no,
सेइंग
I'm clear
कि
about
अगर
the
आप उसको हेल्प करना चाहते हो, देखो हमारे यहाँ व्हेन वी आर लर्निंग दिस क्लास, आवर पर्पस इज नॉट एज एन आरपी. You may be a consultant to the personal guarantor also. We are not doing only as an RP. You might be an advocate who is trying to learn this, right? You might be a consultant also to PG cases. Actually में पैसे वहीं बनते हैं. So if you want to be really want in this profession, be a consultant to PG how to file the plan. So in that case, I'm saying you can take shelter of this, that fine, I am a adjudged bankrupt. अब मेरा क्या करना है आप बताओ. मेरे पास पैसे होते, I would have given it. What purpose it will serve? So NCLT will not help you, but your district court will look into it. They will say कि ठीक है, अब इसको अंदर डाल के कुछ नहीं होगा, इसको 5 दिन के लिए अंदर कर देते हैं, 7 दिन के लिए अंदर करते हैं और जाने देते. So
नहीं
they'll
नहीं
not put you for 6 months. So I'm saying from that angle, if you are consultant, you may advise them accordingly.
So, let us have let me get correctly enlightened. What is the legal position? Legal position is that recovery proceedings are different. Criminal proceedings he will continue to.
Absolutely. Yes, no doubt on that. So
So whatever that is the point. You know,
yes,
अब
yes,
5 दिन की
yes.
सजा हो या 6 महीने की, that is different point. But
मैं 6 को 5 कैसे करना है वो बता रहा था सर आपको.
हाँ,
ठीक.
but जीरो नहीं होगा.
जीरो नहीं होता सर, जनरली नहीं होता, बट वो कभी कभी जज की भी
पर चेक तो बहुत
मंशा.
सारे ने, तो इससे बहुत सारे लोग गए तो नहीं है अभी अंदर.
जी सर. सो इम्पैक्ट ऑन लिमिटेशन. सर अंदर वो तभी डालते जब उन्हें पता है कि अंदर डालने से पैसे दे देगा. ये याद रखिए. जब तक उन्हें पता है तो फ्री में रोटी कोई नहीं खिलाता जेल में. सो जैसे कि अब इसके है ही नहीं, बैंकरप्ट है, क्या करना अंदर डाल. तो इम्पैक्ट ऑन लिमिटेशन. सो आई थिंक दिस इज व्हाट वी वांटेड टू डिस्कस. शायद प्रमोद जी ने भी पूछा था. Impact of section 238A on the limitation act. Considering the purpose of section 238A, 238 is what? Anyone?
Overriding effect.
Overriding effect of IBC.
Absolutely, sir. Non-obstante clause of, right? So 238A is our limitation. Considering the purpose of section 238 of the code, as enacted, is clarificatory in nature, and being a procedural law, had been given retrospective effect, which included application of the so right now you don't need it, but initially when it came, it only used to say whether it is applicable from 2016 or it is applicable from the date when this was enacted. So this was the case where they said, fine, it will be. So after enactment of section 238A on 6th of June, validity whereof has been held by this court, it is not open to contend that the limitation for filing application under section 7 of the code would be limited to article 137, and extension of the prescribed limit in certain cases could only be under section 5. Um, right now you don't need it. Only thing you need to know is it was from retrospective. 3 years is what we talk about. Right now it doesn't impact you. I think we'll skip this one because it's not important for the PG case. Period of, okay, let me just finish this section 18. Section 18 of limitation, however, pose a fresh period of limitation shall be computed from the time when the party against whom the right is claimed acknowledges its liability. So acknowledgement अगर आपने कर दिया, or if the director has done, or he has given any OTS or anything, then it will be considered as a acknowledgement. Even his balance sheets, if he's filing all that, it is an acknowledgement. Then the fresh start will happen and the 3 years will continue from that part.
Acknowledgement by the CD.
No, by the personal guarantor.
Personal guarantor does not give acknowledgement now and then. Only the CD keeps giving.
Absolutely, ma'am. So when the CD is giving, it is a fresh debt.
Correct.
And if you have not invoked the PG till then and you have a continuing guarantee, then there is no problem of
Yes,
limitation.
it has to be continuing guarantee, and CD has been giving the acknowledgement. But statement in the balance sheet, balance confirmation is considered as a acknowledgement.
And even in personal also, sir, if you have invoked and somebody is saying, don't do this, I'm giving you, I'll give day after tomorrow. So till that last thing, it is perfectly fine. It's
No,
covered
I'm
under
talking about
section
the
8.
acknowledgement by way of stating the balance in the balance sheet of the competitor. That is
Ah,
also
okay.
acknowledgement.
That is an extra, certainly that is an acknowledgement, sir.
Sir, what happens if the CD is acknowledging the debt, at the same time the bank has invoked the personal guarantee, however did not do anything?
Yes.
Then
So
what happens, that 3-year limitation for the personal guarantee expires faster than the limitation for the CD.
yes. So actually, I wanted to ask this question, but you have asked this question. What does our forum says? So the question is, PG was invoked. After that, PG is not saying anything. So the PG limitation has started, correct? And CD keeps on giving, yes, yes, we will give, yes, yes, we will give. So what happens in that case?
I think there's a Mumbai NCLT order says, in one of the cases I happened to see that order, where the limitation period for the PG is over, he is out of the guarantee.
Ma'am, either you ask question or you give answer. Don't give both.
Okay.
So let us ask others. Do you think it should or it should not? Who would like to?
If the limitation period is already starting from the date of invocation of guarantee, then naturally after 3 years, it's over. Liability will be over, even though the bank has not done anything in this case.
Yes.
Okay, but let us say the PG, let's say the CD is still acknowledging, yes, we owe you, yes, we owe you, section 18.
Yeah, but then the remedy will be only against the CD, I suppose.
Yes. Because invocation has taken place.
इसमें anybody has doubt? No, right? Good. So, like as ma'am said, NCLT Mumbai also of the same opinion. I think it's pretty logical that you had invoked my guarantee. You did not say anything. Now ask them only, then my guarantee is over if you are not doing anything against me. Right? So I go with that judgment. I also believe is the right answer. If you have invoked me, my limitation starts from that.
However,
Unless
what
you
is
are
the-
getting an
yeah, sir, what is the meaning of invocation? Invocation means to
invocation
pay the
means
due. To pay the
asking the
due.
money. Yes,
Yeah,
yes.
and he has not paid it. Only thing is, yes, the bank has not filed case on the
No, no.
personal guarantee.
Filing case has nothing to do with the invocation. After invocation, uh, I mean, it's my right to file a case. But first you have to ask me. Ask me for money. Then only you can file, right? Then only you can say the debt was due and defaulted. If there is no debt due, until unless you ask me, how can I give you? So first you have to,
Sir, sorry.
it's like raising invoice. Yes.
Normally, when the NPA happens, banks give a what do you call a recall of the loan, letter of
Yes.
recalling.
Yes. Yes.
So along with it, if invocation is not done for personal guarantors,
Yes.
because naturally a copy of the recalling letter will go to the guarantors maybe. Will
Absolutely.
that
Yes.
be enough for invocation? No, a separate
No,
invocation.
that is a gray area, sir, actually. So, in fact, just now Anilji was discussing, and this was one case where we were discussing yesterday. So, this was under section 13(4). I think it was again Bank of Baroda case, where they said that we did not invoke the guarantee. We only informed you that this debt is due from the corporate debtor. We have not invoked it. And if I don't tell you, then tomorrow you will say you did not tell me. That is why we had to tell you, but we have not invoked it. Because if they will say we invoked it, it was invoked in 2017.
Limitation will start.
Limitation will start. They are saying we only did it as a procedural requirement. We did not invoke it. Where is the word invocation? Right? Just now, as Ma'am Bhuvneshwari was asking that, what does invocation actually means? Actually, it only means telling them that this money is due. But then you have to ask me for the money. That Mr. So and so, you had guaranteed, give me the money against this guarantee. That is actual invocation. If that is not clearly asked, then you can, if you are from the bank side, you will say, I have not invoked it. If you are from the PG side, if you are advocate of PG, you will say, no, 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 no. What does invocation mean? It's only English letter. So yes, they have demanded, there is a default, you will fight from that side. But in my view, sir, invocation, if the bank is doing, they have to clearly use the word invocation that we are asking you to give the money against this guarantee which you have given.
Abdul Rahim right now writes invocation also section 13 to notice. Section 13 to notice amounts to invocation of PG.
Yes, yes, yes. So most of the PG are fighting on that part, sir. They are saying, no, we have already, this has been invoked, so it cannot be. In if I'm fighting from the other side, at times, until unless the language is too ambiguous, 13.2 and 13.4, it does look invocation, right? End of the day, isn't it? You are asking me money. Why? Why are you asking me money? Suppose CD pays you, needs to pay you. Why are you giving me notice? You are giving me notice for a reason, right? You are giving me notice because I had guaranteed it. Unless I was a director, unless you are giving me notice in the capacity of a director. See, when you are giving to CD, you give to all directors, right? If you are giving in the capacity of a promoter or director, then this defense I can take. If you are giving me exclusively only because I am related to this CD as as a guarantor, then how can you say that it's not invocation? Then bank will not be able to defend it. Otherwise, why you got me into the picture? You got me into the picture only because of the personal guarantee which I had extended. So again, as we say in law, that is why though we wear black and white coat, but we are always gray. So we say कि लिखा क्या है, right? So I think that's my take right now. Any other
Yeah,
opinion?
yeah, I
Somebody?
think you are right. In 32 notice, if there is no mention of recovery from the personal guarantor, then how it will be considered as a invocation? Personal 32 notice is given to the corporate debtor with a copy to the guarantor, who is a director, you know.
Absolutely,
But it
absolutely.
is not stated you also pay. So then it is not an invocation. Then you have to send separate notice to 30 for 32 to the guarantor also. Or same notice is telling both the parties if this amount has become due, there is a default, you are requested to pay. And mentioning to the first guarantor, mentioning the clause under which you have given the guarantee. I think that is the case, because in our one of the cases, it is not stated. So that 13(2) notice cannot be considered against the guarantor. You have not stated to the guarantor to pay. Is
Correct,
it?
sir. Absolutely right.
So that's a defective.
I
That is a
also
defective.
subscribe to the
That is a
same
defective
opinion.
13(2) as against the corporate guarantor.
Correct, sir. So it is only procedural where you are invoking, and that's what
Yeah.
the banks are taking defense. What courts does is, sir, at times, depends who is more persuasive. So that's how it works.
Okay, one more thing, Devraji.
Yes.
There is in our one of the cases, there is a ambiguity with regard to limitation. But personal guarantor in one of the communication after the PRP commencement has given a letter saying that he is unable to pay and he will cooperate with the PRP process. Will it be taken as an acceptance of that?
सर PIRP शुरू हुई कहाँ अभी?
नहीं,
अगर शुरू ही
appointment.
हो गई है, then there is no worry of
No, no.
limitation.
After the 99 report, you ask him, to
Okay.
cooperate, because
Sir,
we
cooperating, saying that I will cooperate is not an
you,
acknowledgement
no,
of
no.
debt.
When you submit 99 report, before that you ask him to accept the loan. If you
Oh
repaid
yes,
to
if he's
huh.
accepting, then why not? What's wrong in that? Yes,
That's what I'm
yes, yes.
saying. Now
Yes, yes, yes.
see, he has said that. That is why we say it should be recommended. You know.
Sir,
So,
if he's accepting,
but now he is
आपका
raising a
काम ही कर
question of
रहा है.
limitation. Please understand my point.
So
On the
नहीं,
one
so
hand, he
after
has. On the one
thought
hand,
he is
he
raising. Yes.
yes. Now he is raising a point of limitation. He says, I was not accepting this liability. I was generally accepting. So to me, he will not accept generally. I am talking about the PRP of the loan
Exactly.
taken by the bank who has started the process.
Afterthought है, I don't think that will hold much water. So if you have accepted, until unless he has written without prejudice, etc., etc.,
No. He has clearly written that I am not able to pay. I will cooperate and let us start the PRP.
Sir, one question: if limitation period is already expired, then how it can be renewed after acknowledgement, after any
That is the point.
acceptance must be within the limitation period only.
Yes. Even that was a very good point you have raised, sir. Court was saying that it should be within that period, it should be renewed. क्योंकि जो खत्म ही हो चुका है उसको फ्रेश लीज कैसे दे
But
सकते हो आप,
then why he is
राइट?
accepting? He is accepting. He is accepting the liability. He is saying he is not able to pay.
सो
So
आप इस पे क्या कहते हैं?
he himself has renewed the liability. He himself has renewed the liability.
So I would like
We
to
were
go with
saying,
the
talking about
Anil ji
right
in this
now,
case.
the
Yes.
acknowledgement is important. So he is acknowledging.
नहीं सर, just now, sorry, I missed the name किन्होंने बोला था. But section 18 says, मान लीजिए आपने invocation किया and अभी 3 साल हुए नहीं है. So before it reaches to 3 years, 2.9, it has to say, yes, I owe it, then only it extends. Otherwise, it does not extend. The moment 3 is done, then it is tail. But sir, I think if somebody is acknowledging, this is as good as confirming your liability. And if
But
you are confirming your liability, it
Devraji,
will
even
be.
after the limitation period has expired, he is accepting the liability. We are saying acknowledgement. Then where is the problem? Limitation starts again.
मैं आपके साथ हूँ सर. मैं I'm subscribing to your view.
जी हाँ.
जो आप कह रहे हैं मैं भी
Let
वही.
us hope that our principal bench accept this argument tomorrow.
Yes, possible. So, impact of date of declaration. Acha, this is another interesting case. I hope we don't need a break, huh? So it's only half an hour left. Anyone needs break or can I continue?
No need, sir.
It is
No
just like
need.
a break
Okay.
only. We are
सही है सर.
we are on a break from the routine that and discussing
अ-
good things and smiling, laughing. Otherwise, I भी कहाँ हंसता है.
बिल्कुल सही बात है सर. सर हंसते रहना, अदरवाइज वी आर ऑलरेडी इन अ स्ट्रेस
हाँ
कंपनी.
तो स्ट्रेस लोगों का लेते
बहुत
लेते
जरूर,
हम स्ट्रेस हो गए.
बहुत जरूरी है.
स्ट्रेस लोन तो चले गए.
करेक्ट सर, करेक्ट.
हम
सो
स्ट्रेस हो गए.
impact of date of declaration of NPA on the date of default.
एक
So
सेशन
date of
आपको करना
declaration,
चाहिए इम्पैक्ट ऑफ आईबीसी ऑन आईपी.
IPs, हाँ ये करा. No, will suggest ICSI is here. Maybe ये एक सेशन
हाँ,
हो
दिस
सकता.
इज वेरी इंपॉर्टेंट. हाउ टू डील विद स्ट्रेस while dealing stress assets loans.
Correct, sir. Correct. So ordinarily, on declaration of the loan account or debt as NPA, that date can be reckoned as the date of default to enable the FC to initiate the Section 7. However, Section 7 comes into play when the CD commits default. Fine. Section 7 consciously used the word or expression called default, not the date of notifying that the loan of the corporate debtor as non-performing asset. Further, the expression default has been defined in Section 312 to mean non-payment of debt when all or part is due. In cases
हो हो हो
where the
भेटून घ्या मोदी साहेबांना चहा पाणी द्या, काही टेन्शन नाही.
प्रमोद जी, आपको शायद बंद करना
अर्जन्सी
पड़ेगा
काही
माइक.
नाही. ठीक आहे. ओके सर, थँक्यू.
Okay. In cases where the CD had offered guarantee in respect of loan transaction, the right of the financial creditor to initiate action against such entity, being a corporate debtor, would get triggered the moment principal borrowers commit default due to non-payment. Thus, when the principal borrower or the corporate debtor admit and acknowledge their liability after declaration of NPA, but before the expiry of 3 years, the reform therefrom, including the fresh period of limitation due to successive acknowledgement, it is not possible to extricate them from the renewed limitation accruing due to the effect of Section 18. So I think ये हमें सबको clear है अब तक. Acknowledgement means another 3 years. That's all. So if you are advising somebody, tell them not to write an email ever. Okay. Now, including guarantee in resolution plan. Anyone of the opinion? What is the status? Can we include personal guarantee in resolution plans?
No.
No. Okay. Anyone else?
I think in some resolution plans, the personal guarantee is included, and accordingly, the personal guarantor has been relieved of his liability.
So you can, you are saying. Anil ji is saying
If
you cannot.
if the creditors are agreeing, why not?
You are saying why not? Okay. Anybody else?
No, sir, it cannot be.
You are saying it cannot be. Okay, very good.
It,
Okay. Anybody else? Adi Narayan ji said no. Anil ji said no. Madam said yes. भुवनेश्वरी जी ने yes बोला. Anybody else? Any other yes
Sir, if
person?
you know
Joshi
the
sir.
CO, for example, if a personal guarantor is extinguished from his liability by way of a provision in the
Resolution plan.
resolution plan,
Mm-hmm.
if there is a dissenting financial creditor, for
Uh-huh.
example, resolution plan can be passed by 66% majority and remaining probably 30% creditors may be dissenting financial creditor. So
Correct.
what
Correct.
they will do, they should have the option to, you know, fight against the personal guarantor.
So question का answer क्या है sir? What is the answer? Yes, no?
I think it is not possible to
Not
extinguish,
possible.
not
Okay.
possible to extinguish the liability of a personal guarantor.
because
Then what?
उसमें उसमें
Then whatever fees you are paying today is worth it, sir. Because I'll tell you why. You will know. सिंगल साहब आपसे भी कुछ सुनना चाहेंगे.
नहीं, इसमें देवराज जी 2-3 इश्यूज हैं.
अनिल जी आप रुको एक मिनट, पहले सिंगल साहब से पूछते.
Sir,
सिंगल साहब, can this be done or not?
sir, if there is any possibility in plan and COC has approved this same, then there is no problem in my view.
There is no problem. You are saying it can be done, right?
Bench has been, principal bench has asked me one question before admitting one application of PG, that the waiver has been given in the plan to personal guarantor. No, I have said that no waiver has been given. Then this application has been admitted. So in that view, that there is any waiver or personal guarantee etc. can be given in the plan, in the resolution plan.
अच्छा, you are going by that कि नहीं है इसलिए हाँ है, ऐसा?
हाँ.
Okay. So you are going with that premise कि two negatives makes it one positive, right? Okay. Let me try. अनिल सर, हम आपके आंसर को आंसर ले लिया है. एक्सप्लेनेशन मुझे देने दीजिए. I will explain you what the situation is as of today, as on today's date. I can tell. Okay. So Anklet Delhi, in case of Puro Natural Sugars versus Varna Sahkari Bank Limited. This is a case where COC deliberated over the issues and deliberation, I don't know इसमें अच्छे से लिखा है कि नहीं. So in this resolution plan dealt with the security interest and personal guarantee. NCLAT held that, अच्छा sorry, उससे पहले ना हम NCLAT को held नहीं करेंगे. I wanted to, this was a Indore case initially which came. Okay. This is the case. I don't know if it's visible. My screen is visible, right?
Yeah, visible.
Fine. So this was a case in NCLAT Principal Bench, New Delhi. Same, pure natural, the one I was showing in the PPT. I'll just explain you here what is happening. In this case, there were two incidences where the resolution plan said that fine, we will give you some money, you release the personal guarantee. Now there are two views on this. Why a new SRA is interested in releasing the personal guarantee? What is the reason? Why will they pay something extra for that? They should not, right? Unless they are related or they are connected to the personal guarantor or they have taken some money from them and they are giving it here. Something like that is happening, right? Unless that. So in this case, I have, I think, underlined that portion. This was a case of Naveen Kumar Sood versus Ujas Energy. Fine. In this case, here the RP has sought to distinguish the cases where arguing that resolution plan only assigns the personal guarantee and does not extinguish. So एक होता है extinguish कर देना, एक होता है उसे assign कर देना, right? Are both of these allowed or not? So NCLT Indore bench in these cases They said this cannot be done and they rejected the plan. They rejected the plan. Why they said what they said? They said COC can take any commercial decision related to the insolvency of the sorry. COC can take any commercial decision relating to the insolvency of the CD only. COC cannot extinguish right of the particular secured creditor to proceed against the personal guarantor of the CD under the grab of commercial wisdom. So NCLT clearly said no. Since this is not correct, such provision in the resolution plan is prejudicial. They rejected it. Now, what do you think would have happened? Challenge होगा, right? Commercial wisdom के उसमें नहीं, they did not allow it. Now this went to NCLAT. Now NCLAT, obviously we had all senior advocates fight for it. NCLAT said, okay, they also said that it is, it's an established or settled law that in the resolution plan, the security and the personal guarantee in favor of financial creditor can be very well dealt and extinguished. This was the case. Company Appeal, SVA Family Welfare Trust and Ujas Energy Limited. I want to show you one page where all securities and personal guarantees are sought to be extinguished on mere payment of 2 crores, whereas the value of these securities are much more. Obviously, much more means they would have covered the entire spectrum. 40-45 crore की security थी. 2 CR के लिए they have given away, which was in this case JP Kensington Boulevard Apartments Private Limited. NCLAT has actually overturned this judgment, saying this can be dealt if the COC is interested. Now, somebody was saying what happened to the dissenting financial creditor? Unka kya hoga? Right? I think whose question was that? Can you please remind me?
Joshi.
Joshi, okay. Joshi ji, you had a very correct question, and this you can read here. It says dissenting creditors on extinguishing of PG liability. So I'll share this case with you. This case actually talked about whether it can be extinguished or not. Now, I have highlighted that page here. So two principal questions which arose in this appeal was whether resolution plan providing for extinguishment of security and the guarantee of the financial creditors, including dissenting financial creditor, is contrary to the provisions or not. Fine. And the answer is, it goes here. First question, whether it can be included or not, which was given by the promoter to secure the debt. Various clauses of the resolution plan as extracted above clearly notes that the resolution plan specifically dealt with securities and guarantees of the FC, and the plan envisaged extinguishments of security. Also, they are making some payment also towards it. Whatever, chota hai, bada hai is not a problem because COC they are saying is taking care of it. Now, here, tribunal held in the aforesaid judgment that security interest of the dissenting financial creditor by virtue of personal guarantee of the ex-director of the CD could have been very well dealt in the resolution plan. So NCLAT का opinion ये है sir, ठीक है? Now NCLAT is not Sarve Sarva, right? We still have somebody else, right? We can look into that. So tribunal took the view, this tribunal, that is appellate tribunal, took the view that resolution plan providing for extinguishment of personal guarantee as approved by COC did not contravene. It is, since they are also making some money out of it. Also, this decision of Bank of Baroda, there was an appeal filed against this decision, and this appeal has been dismissed by the Honorable Supreme Court via its order dated 9th November. And when they are dismissing the appeal against NCLAT means जो NCLAT का order है वही upheld. So right now the law of the land is that this is possible, and if the COC is saying it can be knocked off, it will be knocked off. So question number 1 ka answer is mentioned here. Consciously dealt with this. Resolution plan does not contravene, so it is allowed. Now this is the situation there. But if that is so clear, and I'll show you this. This is visible. I've changed the screen, so I just wanted to ensure.
Yes, sir.
It is visible. So this is 11th of November, right? Yesterday's. Extinguishment of promoter's personal guarantee in resolution plan is valid if plan complies with IBC. NCLT Mumbai. कल सुबह तक की ये खबर है. ठीक है सर. NCLT Mumbai, ये आप केस देख सकते हैं. You can find it. So right now NCLTs are taking this view that this can be done, no problem. But if this is so easy, if this is done, right? In fact, IBPI in its write-up also shared this in this. On 21st of August, they said judgment of so and so whether a clause providing for extinguishment of personal guarantee given to the FC is valid or not. So here they said fine, court has said this, it is valid, it can be done. So IBBI in its write-up said yes, it can be done. But what happens here? Discussion paper. You know what happens here? This came on 19th of June. Discussion paper by IBBI. Okay, I'm calling it discussion paper because so far it has not been implemented. Here on page 4, what they said? Now they are saying release of guarantees in the resolution plan. They need your opinions. Okay. It has been seen that there have been multiple orders of various judicial authorities dwelling upon the diverse facets of the issues regarding the treatment of guarantee in a resolution plan, sometimes even in contradictory manner. In order to have clarity in this regard, it is proposed to follow the approach of the Honorable Apex Court in the matter of Lalit Kumar Jain versus Union of India. इसमें हमने क्या पढ़ा था? Wherein it was clarified that approval of a resolution plan does not automatically release its guarantor from their liability. Fine. Now their proposal is to ensure that there is a clarity on the rights of the FC to enforce recovery under guarantee agreements. It is proposed that CIRP regulations to be amended to clarify that the resolution plan submitted by the resolution applicant shall not extinguish the rights of the creditor to proceed against the guarantors and enforce realization of guarantee through various agreements. Here they are asking for all our IP's comments that it should be done, it should not be done, and you can file it by so and so. Now this was filed on 10th of July. I think it's been more than 5 months. But we are yet to see any comment from IBPI in this case. But view is this, sir. I think you can, our regulator is of this view right now. Because if they are not of this view, then why will they bring it out for public, discussion?
Sir, can I say something on this?
Yes, please.
With respect to this extinguishment, as you rightly pointed out, see, if it is a related, let us say the promoter, under the guise of many times they say we are an MSME, so we are submitting resolution plan. At that time, he can also say the proposal is to extinguish the personal liability.
Yes.
And the COC finally, whether they go after the promoter through the CIRP or through the personal insolvency, it is the very same guys, so they are accepting it.
Absolutely.
That is fine. But if it is a third party resolution applicant, why should he give a plan saying that, personal liability is to be extinguished. Then he has
Correct.
to pay the money also what is due from the personal guarantors.
Absolutely the right answer, ma'am. In fact, that is the whole idea, that why somebody, a third party, is ready to give money for somebody else's liability. And that too when they are not related. They are, see, we have taken their consent under 29A. We have taken their affidavit. They have said we are not related. We have nothing to do with the erstwhile management. Zero relation, isn't it? So if it is MSME, same management taking over, I can understand. Why a new person will have to give? Unless there is a collusion. So unless there is a collusion, nobody is interested in getting it freed, right?
Also, one of the participant told about section 32, where the dissenting financial creditors. See, dissenting financial creditors' right should be kept intact. How can it be taken away by saying that, resolution, even if the promoter is giving it? If he is dissenting, his right should not be taken away. Otherwise, the
Ma'am,
provision of the code itself goes for a toss.
Bhuvneshwari ji, unluckily, NCLAT principal bench, Justice Bhushan does not agree with you. I agree with you, but he doesn't agree with you.
No, but one thing, in the order of Supreme Court, this Lalit Kumar Jain, it says,
Lalit Kumar Jain was earlier, sir, before
no,
this.
no, 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 Supreme Court judgment, it says it will not be automatically extinguished.
Exactly.
It
They
means
use
it
the
has to
word
be dealt with.
automatically.
It means
Yes,
it
yes,
has to be
yes.
dealt with.
Yes,
So
yes,
if
yes.
it is dealt with, you know,
सर अगर
see,
डेल्ट विद है, अगर डेल्ट विद है, हमारी यही तो
the
बात हो रही है कि
only thing is that if it is not, it is by the same promoter, then it is okay. If it is not by the same promoter, then why the SRA should be interested? That is the
तो ये
question.
आई तो ये आईपीपीआई क्यों ला रहा है सर ऐसा
That is, नहीं,
डिस्कशन पे?
IBPL ठीक ला रहा है. वो कह रहा है कि it has to be properly, regulation has to be changed. That if it is the same promoter, then same promoter would like to be free from all the liabilities, whether personal or corporate debtor. So he is paying separately for the personal guarantee also. Take 2 crore for the personal guarantee. Take plan for
Okay,
this amount, but third party will not pay. So that has to be distinguished.
fair enough.
So
So
that
your
Also,
point is, your
हाँ,
point is
also,
कि
here.
yes,
Also, if the resolution plan is from the promoters, from the suspended directors, whoever it is, then the buffet transaction should also be dealt with. It cannot hang loose when the personal liability is one side extinguished, one side CD's liability is extinguished, and buffet application will be kept
No,
separately.
Pufe has to be dealt with separately. Pufe has to be, because now there is regulation that it will be stated what will happen to the Pufe transactions, who will follow up and who will be the beneficiary. That is stated in the plan.
सर उसमें डाउट नहीं है.
हाँ.
Our issue was,
Hmm.
if somebody is taking care of personal guarantee, don't you think they will take care of PUFE automatically? They are smart enough. So if it's the same
No, no, that is
promoter
that,
who is
sir.
coming with a
No, no, that is
MSME,
dealt with separately. Pufe transaction will be separately. Personal guarantee is separate. Pufe transaction, you are not giving immunity for the offense committed. If you have
मान लिया
diverted the money, if you have
मान
done
लिया
the
सर.
fraudulent to defraud the creditors, that immunity cannot be given by the resolution plan. Personal guarantee is a commercial decision he has given, you know, and criminal act cannot be given exemption by the resolution plan or by the NCLT. Even NCLT will not give.
इसमें सर थोड़ा ओपिनियन का डिफरेंस ये है,
हाँ.
मेरे खिलाफ केस है, आई टेक ओवर द कंपनी अंडर एमएसएमई 240A में मैंने ले लिया,
हाँ.
राइट?
जी हाँ.
आई विल असाइन इट टू अनिल जी. या पहले बात तो मैं अपने आप को ही असाइन कराने की कोशिश करूंगा, वो आप अप्रूव नहीं करोगे. आई विल असाइन टू माय पर्सन ओनली. हु
What
विल
you will
नॉट
assign?
परसू इट? हु विल नॉट परसू उसको? सर उस
So
केस को कोई तो
whatever,
परसू
no,
करेगा
whatever,
ना.
whosoever follows up, that
सर कोई
ultimate,
करेगा ही नहीं ना.
no, no, no,
मैं
क्यों नहीं करे? That will be,
आ,
that is what is, see, that is
आ,
lacking in the discussion paper which is latest has come. It is
करेक्ट
also that what happens to the implementation of the resolution plan.
करेक्ट सर
So
यही कह रहा हूँ.
that is a gray area. That is the untouched
That is
area
still
so
a
far.
yes, yes,
So
yes.
so
अभी भी we have
so
gray
if
area.
somebody does not pursue the NCLT sumoto will not take initiative. But if it is pursued, then definitely the court will give judgment. Whether something has right, whether judgment comes today or after 20 years, that is again different issue. You know, but
Sir,
resolution plan cannot give immunity for the criminal offense done under POFE or diversion of fund. Both.
नो प्रॉब्लम सर, असाइनमेंट तो कर सकते हैं ना, और जिसको असाइनमेंट करेंगे उसको बोल देंगे फॉलो
So
मत
I
करना।
can find technique to save myself, but there is no legal. See, I can
Correct,
delay.
correct.
I can
I
delay.
agree sir,
I can delay. You know,
मैं
and
एग्री कर
I
रहा हूँ
can
सर आपकी।
technically do in such a manner that it actually is delayed to an infinite period. But
POFE
now,
you can't say कि it goes away, correct,
it
I
goes away.
agree on that, I
So
agree on
if
that.
suppose there are 100 applications, one can be taken up by the NCLT,
Absolutely,
and
absolutely
there
sir.
can be judgment. But whether
I
today or
am,
after 10 years, you know, but the case continues.
I 100% agree with this.
Yeah.
Okay, so we'll go to कितनी PPT? अच्छा 4 ही बची है, so we'll finish it up. Liability of co-guarantors, I don't think we have any problem in this. We all know. Release of corporate guarantor. Corporate guarantor is a company giving guarantee to the company, right? Now, in this case, Central Bank of India, ISCON Infra Engineering, Educating Authority rejected the dissolution of a company. This was interesting. I think we should read it. Adjudicating authority rejected the dissolution of a company which was undergoing voluntary liquidation. You know why? Because they had given guarantee for somebody. They had given guarantee, corporate guarantee to somebody. And then on the other side, they said, we are going for voluntary liquidation. हम खत्म ही कर देते हैं. So it was rejected. The fact that guarantee has not been invoked does not absolve the corporate guarantor from the debt. ये याद रखने की चीज है सर.
I didn't get you.
Invocation.
I didn't get you, sir. Can you please?
Yes,
1 minute.
yes, yes. इसको धीरे धीरे पढ़ेंगे सर.
जी
It's
sir,
important.
जी.
Voluntary liquidation, one company is going.
Okay.
They are saying they have filed voluntary, saying ये हमारी कोई liability नहीं है.
जी हाँ.
तभी तो voluntary कर
हाँ,
सकते
तभी
हो,
voluntary
वरना
होगा,
तो कर,
100%
right?
पेमेंट है.
100% पेमेंट है, हमारी कोई liability नहीं, हमें खत्म कर दो जी.
जी हाँ,
Right? कोर्ट सेट कि आपकी 100% कैसे सेट है? आपकी लायबिलिटी तो गारंटी भी है.
हाँ हाँ,
अब गारंटी भी तो आपकी लायबिलिटी है.
बिल्कुल गारंटी भी
उन्होंने
है.
कहा सर
और
गारंटी
प्रोफिट
हमारी
डायरेक्शन भी
लायबिलिटी.
है. प्रोफिट डायरेक्शन भी है.
नहीं, पूफे तो बात की बात है ना सर.
जो सर
पूफे
अगर आप
सर हर जगह पूफे को नहीं घुसाएंगे सर हम.
नहीं
ठीक है.
नहीं, वो भी है ना. अगर कोई केस चल रहा है,
अच्छा हो ना हो हमें नहीं
सर कोई
पता ना
लीगल
सर.
केस चल रहा है, वो डिसाइड नहीं हुआ है. मेरा सबमिशन ये है. प्रोफे से चलो, प्रोफे छोड़ दीजिए.
सर आप
ये
इसे पढ़िए. कॉर्पोरेट गारंटर की बात हो रही है मेरी
हाँ
सिर्फ. वी आर टॉकिंग अबाउट कॉर्पोरेट
हाँ
गारंटर.
हाँ,
समबडी
गॉट
गिव
इट, गॉट इट.
गारंटी,
वही
राइट?
एनी काइंड ऑफ गारंटी विच इज नॉट एग्जीक्यूटेड सो फार, यू नो, एनी केस विच इज पेंडिंग ऑन.
which is not even invoked.
या नॉट इवन इन्वोक्ड.
Invoked नहीं है तो भी does not mean कि it is finished.
नो, इट इज नॉट
या तो आप उसे रिटर्न करो,
या तो
then
अपनी
only
गारंटी
you go
वापस
for
लेके आओ, यू नो.
absolutely. या तो उसे खत्म कराओ, because liability of the CG
उसे
is
उसे
co-extensive
एनओसी
होता है
लेके
ना.
आओ और गारंटी खत्म करो. देन ओनली यू विल, बिकॉज उसका प्री कंडीशन ये है कि 100% पेमेंट हैज बीन मेड टू द क्रेडिटर, यू नो. वो अननोन अमाउंट है आपका.
बिल्कुल ठीक बात है सर.
तो वो
क्योंकि
उसी कंटेक्स्ट में मैं कह रहा था कि जो लीगल केस या प्रोफिट ट्रांजेक्शन चल रही है, तो दैट आल्सो हैज टू बी एक्सटिंग्विश्ड. एक और भी केस है ऐसा जिसमें ऐसा है, यू नो.
होंगे सर, बहुत सारे होंगे. सो
हाँ,
सम ऑफ द केसेस व्हिच वी कुड आइडेंटिफाई इज
आई एम जस्ट
देयर.
सेइंग, यू नो.
Yes, yes.
जी.
One
This we
point
have
is,
learned, sir.
point is the limitation will start only when the demand is made.
Yes.
If it is continuing guarantee,
Yes, yes, yes. You're right.
the continuing guarantee cannot continue for the nth period. It will
Why
have
not,
to
sir?
stop. It will have
Why
to
not?
stop. No, it
No,
will
why?
have to stop some point of time.
No, sir, it will not stop till
Unless it has been
I
paid.
recover
No,
it.
no, no, no.
Or invoked. Or invoked.
Exactly. Yes, that's what
Yes.
I wanted to
Yes,
say.
sir.
When demand is made or it is invocation, upon invocation, even if it is continuing guarantee, then the limitation period start running.
and
हाँ हाँ
limitation
सर
and limitation period will not stop, and
हाँ
it
सर
will not
हम हमें
renewed also.
नहीं सर इट विल बी रिन्यूड इफ देर इज फ्रेश एक्नॉलेजमेंट क्या प्रॉब्लम है
Yes, that is
सो सेक्शन
it
18 अलाउज दैट बट
right.
सर लास्ट 3 आवर से हम यही डिस्कस कर रहे हैं
हाँ,
इन्वोकेशन इज द क्रक्स
right.
जहां इन्वोकेशन हुई वहां से 3वां महीना चालू है सो इट्स लाइक जैसे वो पहले पेज भरते थे 3 इयर्स अलाउड है अगर वो खत्म होने से पहले आपने दोबारा भर दिया तो फिर से 3 साल अलाउड है फिर से 3 साल अलाउड है सो यस यू आर राइट ये आई थिंक वी आर ऑन द सेम पेज ऑन दिस सर वट एवर यू से
And
and
one more thing,
same
if
RP
the
can be
if the company is in CIRP, in that case, the personal guarantors who were the directors also of the company, or those are the suspended board, the member of the suspended board of the company of the CD, which is in CIRP. And during the CIRP, they acknowledges again in the capacity of director.
सर डायरेक्टर इज सेपरेट देन पर्सनल गारंटर दोनों का
No,
रोल अलग अलग है
but
नहीं
they
नहीं
are
दोनों
personal
का रोल
guarantor also. Simultaneously, they are director also. However, they are
दैट इज द होल ब्यूटी ऑफ वर्डिंग्स इसीलिए भाषा का खेल है ये सो इफ दैट पर्सन इज एक्नॉलेजिंग एज अ डायरेक्टर ही कैन से पर्सनल गारंटी अलग बात है डायरेक्टर अलग बात
बिल्कुल
डायरेक्टर तो वैसे भी लायबल होता है देन व्हाट इज द यूज ऑफ पर्सनल गारंटी
he is accepting on behalf of the company as a director.
Yes, exactly. That is what. If they are accepting, though the company is under CIRP, moratorium is there.
No, sir.
Whether and further, my friend has said that they have.
सर एक करके बोलते हैं नहीं तो दोनों ही नहीं समझ पाएंगे हाँ
They have accepted the acknowledgement on behalf of the company. I want to ask, sir, whether this acknowledgement is a valid acknowledgement, because the company is under moratorium 1. Second is the company is in the hands of the RP. So it is RP who has the authority to acknowledge the guarantee. So whether that acknowledgement in the capacity of director will be deemed as a personal guarantor.
No, RP will not accept as a guarantor.
No. Sir. Let me answer it. It's a good question. CIRP जब चल रही है, what is the use of acknowledgement? जब CIRP चल ही रही है, there is no meaning of acknowledgement by the CD.
Right.
There is no.
It is, sir. ये क्या होना चाहिए और क्या नहीं? It has happened actually. I'm
obviously you are giving us a live case. I'm only saying as a director का तो कोई मतलब ही नहीं है ना admission का.
Okay.
क्या करेगा वो? Why are you admitting? पहली बात तो कोई पूछेगा क्यों उससे?
Nobody will ask. He will submit the claim.
अरे सर डायरेक्टर थोड़ी सबमिट करेगा
नहीं मैं कह रहा हूँ फाइनेंशियल क्रेडिटर will submit the claim. Claim will be admitted.
Absolutely. You file it with the RP. RP will decide whether ये time barred है नहीं है और whether it can be admitted. वो admit हो जाएगा.
Sir, for XYZ, sir.
No.
For
RP
XYZ.
No, Devvart ji. When the CRP has commenced, RP will not decide about the admission of claim by the financial creditor on limitation ground. RP will accept the claim by the financial creditor.
सर हम उस पर किसी और दिन क्लास ले पाएंगे मेरे ओपिनियन उसमें थोड़े डिफरेंट है अब किसी का 10 साल पहले डेट खत्म हो चुका है क्लेम खत्म हो चुका है विल यू एडमिट इट
अरे सीआरपी हैज कमेंस्ड
अरे तो सीआरपी कमेंस हुई है ना सीआईआरपी डज नॉट गिव लीस्ट ऑफ न्यू लाइफ टू द ऑलरेडी बार्ड डेट नहीं तो फिर जो 20 साल पहले मेरा क्रेडिटर था वो भी उठ के आ जाएगा कि सीआईआरपी चल रही है
ओके
मेला थोड़ी लगा हुआ है सो हाउ कैन वी से सो दैट्स व्हाई आई एम सेइंग हम आज उसको टच नहीं करेंगे टुडे इज नॉट दैट आज का हमारा टॉपिक है
the case is different actually my case is I am talking about the different thing probably
सर जो आप बोल रहे हैं उन्होंने एक्नॉलेजमेंट की एंड बैंक इज यूजिंग दैट डिफेंस कि इट इज अ
एग्जैक्टली
सर ऑब्वियसली आप ट्राई करोगे बैंक भी हर पैतरे अपनाएगा दैट्स व्हाई आई सेड व्हेन वी आर लर्निंग we are not learning as an RP. We are also learning as a consultant to the bank or to the other side also. उसने हाँ कर दी डायरेक्टर ने. हो सकता है डायरेक्टर इज कमिंग टू यू फॉर कंसल्टिंग के I have agreed but not as a personal guarantor. Then you will say, where is the word as personal guarantee? Where is it discussed? Where is the debt discussed? The debt has been discussed as an erstwhile director. Okay, now director is there, only his power is suspended. There are 1,000 ways to say, why, I have acknowledged because fine, you are asking me, I have said yes, we are supposed to give. But whether I have to give as a personal guarantor or not, that is two different things. So it
But sir,
depends.
I have put this defense, I have put this argument before the NCLT that yes, though on record the stamp bears the word director. They are doing it. They have done it on the pretext that they are signing is acknowledging it as a director during the CIRP. But they were not authorized to do that. So they should be deemed that they are acknowledging it in the capacity of personal guarantor.
सर डीमिंग तो आप डिफेंस लोगे ही ना सर. आप लेते रहो. वो कहेगा ऐसे थोड़ी होता है. सो आई मीन एज आई सेड डिपेंड्स आप किसकी तरफ से हो. सो एंड तीसरी तरफ एक
एक बात को कंक्लूड कर दीजिए देवव्रत जी. When he is signing as a director, he is the same person. He is accepting the liability. So how can he say that as a guarantor he is not accepting? When the liability is coextensive and the guarantee is continuing, how he will say no?
मैं बताता हूँ सर. आपने मेरी इन्वोक की थी 4 साल पहले. उस पे लिमिटेशन होके खत्म हो गई.
अच्छा.
आपने मेरे खिलाफ कुछ नहीं किया.
अच्छा.
ये दोबारा कैसे शुरू हो जाएगा? अभी थोड़ी देर पहले तो हमने बात की सर.
कोएक्सटेंसिव है. अगर वो पहले कर चुके हैं तो एज ए डायरेक्टर तो कह रहे हैं, वो एज ए गारंटर वो मना कर देंगे.
चलो सर, आपकी बात राणा साहब, मैं आपकी बात को आगे बढ़ाता हूँ. आपने कहा कि 3 साल, मैं कहता हूँ 3 साल से पहले उन्होंने इन्वोक की, 3 साल का समय निकल गया, उसके बाद उन्होंने ओटीएस दिया.
विद इन 3 इयर्स दिया
ना बाद में दिया.
किसने दिया? गारंटर ने दिया, कंपनी ने दिया?
गारंटर ने दिया. बैंक
बस एडमिशन हो गया. फिर तो एडमिशन हो गया. वहां से ओटीएस की डेट से शुरू हो जाएगा 3 साल.
एज अ वर्ड गारंटर दिया तो हो जाएगा.
कौन सा सेक्टर?
अगर एज अ वो दिया है सर, एज अ गारंटर तो मिलेगा, नहीं तो नहीं.
हाँ, एज अ गारंटर अगर ओटीएस दिया है तो 3 इयर्स पीरियड विल स्टार्ट फ्रॉम द डेट ऑफ ओटीएस.
चाहे सर आफ्टर 3 ईयर दिया हो, जो लिमिटेशन का पीरियड निकल गया है उसके बाद भी दिया.
हाँ, ही इज एडमिटिंग एज अ गारंटर. और यही तो बात है
सर. ये इंडियन कॉन्ट्रैक्ट, राणा साहब, इंडियन कॉन्ट्रैक्ट एक्ट का एक सेक्शन है,
ये रहा अभी पढ़ा हमने थोड़ी देर.
प्रॉमिस वाला, कि प्रॉमिस करता है वो कि ओटीएस के बाद मतलब ओटीएस दे रहा है वो, और वो दैट फॉल्स विद इन दी.
मुझे उससे प्रॉब्लम नहीं है. उसने एज अ गारंटर
सर सेक्शन 25 देखेंगे आप अगर.
उसने एग्रीमेंट इफ मेड विदाउट कंसिडरेशन इज वॉइड है सर 25 तो.
और इज ए प्रॉमिस टू कंपनसेट फॉर समथिंग डन, और इज ए प्रॉमिस टू पे ए डेट barred by limitation law. That is the thing, barred by limitation of law. किसी ने 2020 में इन्वोक कर लिया और उसने 2024 में अगर उस सेम डेट को फरवरी मार्च या मतलब अब 2024 में उसको वो ओटीएस देता है, तो दैट फॉल्स विद इन दी सेक्शन 25 सर.
सर मान लिया उसने जब दिया है, इज ही गिवन इन द कैपेसिटी ऑफ अ डायरेक्टर और इज गिविंग इन द कैपेसिटी ऑफ अ गारंटर? अगर ये गारंटर दे रहा है तो फिर ले लो ना, प्रॉब्लम का है. देन वी विल टेक शेल्टर ऑफ सेक्शन 25 ऑब्वियसली.
राइट, दैट्स व्हाट आई वांटेड.
देन तो जाना ही है. ओनली थिंग इज यू कैन नॉट प्रिज्यूम कि अनलेस इन दैट ओटीएस इट इज मेंशन्ड कि गारंटी भी इन्वॉल्वड है. आप प्रिजम्पशन नहीं कर सकते. दे विल हैव डिसेंट डिफेंस अगेंस्ट इट. दैट्स व्हाट आई एम सेइंग. वी आर, हम अलग बात नहीं कर रहे, हम एक ही बात कर रहे हैं. बट वी आर सेइंग वर्डिंग के ऊपर बहुत डिपेंड करेगा सर. आवर लॉ इज ऑल अबाउट वन वर्ड, राइट? आपने देखा होगा एनसीएलटी में हम क्या करते हैं सुप्रीम कोर्ट में, वो एक शैल और मे के वर्ड पे 3 दिन एक बार मैंने हियरिंग सुनी है, शैल और
हाँ
मे,
सही है।
राइट? सो इट्स ऑल अबाउट व्हाट इज एक्नॉलेज्ड, व्हाट इज नॉट एक्नॉलेज्ड, इन व्हाट कैपेसिटी दे आर एक्नॉलेजिंग। वो सर बिना पढ़े ना क्लास में ऐसा डिस्कशन नहीं हो पाएगा पर्टिकुलर केस का। बट यस,
राइट राइट
एक्नॉलेजमेंट है, रिवाइव हो जाएगा। एक्नॉलेजमेंट क्लियर नहीं है, नहीं होगा। सो
आप तो
आई
इन
शेयर,
प्रिंसिपल ये डिस्कस कर रहे हैं कि क्या इस रास्ते
Yeah.
पे चल सकते हैं बेसिकली, फिर
certainly
उसका
certainly certainly sir,
निटी
certainly
ग्रिटी, हाँ
20
निटी ग्रिटी फिर।
yes,
हाँ
absolutely sir. So section 18 बहुत इम्पोर्टेंट है हमारे लिए। 126 बहुत इम्पोर्टेंट है, कॉन्ट्रैक्ट एक्ट का नहीं
राइट।
पढ़ा दोबारा पढ़ लीजिए। 126, 128, 130, अच्छा 131 वॉज कि अगर इसकी डेथ हो जाती है तो कर सकते हैं कि नहीं कर सकते। सो इसमें एनी लास्ट पॉइंट विल डिस्कस फॉर द डे। अगर श्योरिटी की डेथ होगी, कैन वी इनिशिएट पर्सनल इंसॉल्वेंसी?
सर फिर वही इसमें ना, मेरे केस में मैं बताता हूँ आपका, इसमें जो गारंटी एग्रीमेंट है उसमें लिखा हुआ है कि अगर इसमें उसकी डेथ भी हो जाती है गारंटर की, तो उसके बाद उसके लीगल रिप्रेजेंटेटिव को भी इसमें इन्वो लेकर के जा सकते हैं, उसके
और
गारंटी एग्रीमेंट में लिखा हुआ है।
नहीं भी लिखा हुआ सिंगल साहब, तो लिक्विडेशन जो उसकी असेट्स है उसके अगेंस्ट, असेट के अगेंस्ट कर सकते हैं हम इंसॉल्वेंसी।
अगर
राइट सर,
एसेट्स, हाँ अगर एसेट्स
इट इज
हैं
सिविल लॉ।
तो
यस सर।
हाँ,
एग्जैक्टली अगर अगर एसेट्स हैं तो हम उनके केस कर सकते हैं, लेकिन पीजी नहीं शुरू हो सकती।
पीजी नहीं होगी, पर ट्रस्टीशिप शुरू हो जाएगा वंस द एसेट्स आर एस्टैब्लिश्ड।
सिविल लॉ हम पढ़ेंगे ही नहीं आज, ठीक है? सीपीसी में आप जो मर्जी कर लीजिए, इंसॉल्वेंसी में 94 95 नहीं हो सकता।
नहीं नहीं, मैं बैंक्रप्सी ट्रस्टी की बात कर रहा हूँ सर।
सर
अगर रिकवरी
बैंक्रप्सी
प्रोसीड,
ट्रस्टी किसका किसका ट्रस्टी बनोगे सर?
उनकी
अच्छा
एसेट्स का,
नहीं 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 हो
उनकी
सकता
एसेट्स
सर,
का लिक्विडेशन एसेट का,
नहीं हो सकता सर।
जब उसके खिलाफ
नहीं
असेट्स
हो
हैं।
सकता, नहीं हो सकता सर, नहीं हो सकता। 121 की 121 पढ़िएगा। मे बी विल रिक्वेस्ट आईसीएसआई टू कंडक्ट अ ट्रेनिंग ऑन बैंकरप्सी, क्योंकि
हाँ,
बैंकरप्सी शुरू ही तब होगी जब पर्सनल
अभी
इंसॉल्वेंसी
बैंक्रप्सी
फेल
शुरू
हो
नहीं हुई है
जाएगी।
ना, अभी हम इंसॉल्वेंसी पे अटके हुए
नहीं आई
हैं।
एम,
और अभी भी बैंक्रप्सी पे पहुंचे नहीं है सर हम अभी।
हाँ, पहुंचे नहीं है अभी।
नहीं सर, आई एम डूइंग बैंकरप्सी इन वन ऑफ द मैटर,
और असली चीज ना
850 करोड़।
राणा साहब, असली चीज बैंकरप्सी ही है, यहाँ पे तो
हाँ।
हम पोस्टमैन का और ये वाला काम कर रहे हैं।
नहीं सर, आपकी दुआ से आई एम डूइंग अ बैंक्रप्सी केस ऑल्सो
वेरी गुड
इन
सर।
हैदराबाद। इट्स
वेरी
अ
गुड, वेरी गुड।
850 करोड़ केस। ऑल द बैंकर्स आर देयर, एसबीआई सारे हैं उसमें फंसे हुए।
आपकी गाइडेंस लेंगे सर हम फिर तो।
और फीस, फीस में शेयर भी लेंगे।
हाँ
पहला
हाँ
के,
बिल्कुल सर।
पहला के
वो
नहीं, आपके आपसे नहीं कह रहा हूँ, राणा जी से कह रहा
वो
हूँ।
पब्लिक प्लेटफॉर्म पे कहने की बात नहीं है, वो कर
नहीं
लेंगे
सर,
राणा साहब से बात।
आई टेल यू, बैंकरप्सी में एक्चुअली में बहुत पैसे हैं।
हाँ,
पीजी में तो 25,000 रुपये आते हैं, बट इन
वो भी नहीं आते।
बैंकरप्सी में देयर इज अ वाटरफॉल मैकेनिज्म, वो शेड्यूल
राइट
बना हुआ है लाइक
हाँ
लिक्विडेशन। सो अगर
हाँ
बैंकर ना एग्री करे कोई प्रॉब्लम नहीं है। सो बैंकर एग्री कर जाए तो ठीक है, नहीं करे तो भी कोई प्रॉब्लम नहीं है। आई एम गेटिंग 2 लाख प्लस जीएसटी इन बैंकरप्सी मैटर पर मंथ। सो
वेरी गुड।
आपको मिल जाते हैं, इतने तक का आपको उम्मीद है, बिकॉज ये बैंकरप्सी में एक्चुअल काम है।
हाँ।
पीजी में कोई जब बहुत ऐसा, अनिल जी को छोड़ देते हैं, आई नो अनिल जी के मैटर। अनिल जी इज एक्चुअली माय पार्टनर इन आरआरआर, सो अनिल जी का मुझे पता है, बाकी आई थिंक इतना प्रॉब्लम नहीं है। आई विल शेयर दीज पीपीटीज एंड सम ऑफ दीज केसेस विद यू इन आईसीएसआई, एंड आई थिंक अंजलि जी, इफ यू आर हेयर वी कैन, आई होप वी कैन कंक्लूड इट। आई होप इट वाज अ
विद वोट ऑफ
लर्निंग
थैंक्स।
सेशन विद बोथ ऑफ them.
वेरी
our sincere vote of thanks to Rana ji for refreshing our knowledge and discussing in a
Obliged,
very friendly manner, you know.
obliged, sir.
जी जी।
यस, इट
हाँ
इज
जी,
वंडरफुल डिस्कशन।
हाँ, वंडरफुल। और बैंकरप्सी ट्रस्टी का एक्सपीरियंस शेयर करिएगा, ताकि जब केस मिल जाए, और फीस तो बाद में ले लेंगे आपसे।
hopefully in a month or so, I mean, within this month, if time allows, we will
हाँ,
conduct a
फीस
session
तो हम
on
एज ए पार्टनर
bankruptcy.
शेयर कर लेंगे, पर
सर बीटी और आईपी में पैसे मिल जाते हैं, जब मिलते हैं तो अच्छे मिलते हैं,
तो
जब तक
हाँ,
नहीं मिल
अच्छा,
रहे तब तक कोई बात
ईश्वर
नहीं
करे
है।
सबको मिलते रहे, क्यों जी।
मिलेंगे सर,
राइट
मिलेंगे।
सर, बिल्कुल
जी।
तो अंजलि जी, वी आर done for
Yes,
the day?
sir, we can conclude.
Oh,
Thank you very
so
much, sir, for such a knowledgeable and insightful session. Sir, please share the PPTs.
I'll
Yeah.
share right away with you. You can
Ji,
then
ji, ji.
disseminate. Fine.
Thank you, Rana ji.
Okay,
Thank you.